Okay, clear. I'm mentioning there is a joint prayer with regard to item number 13 and 14, my lord.
Okay.
These two matters were already admitted, my lord. So these may be posted on 25th or 34th, 2020 for hearing.
13 and
13 and 14. Along with WPC number 2307 of.
but it is connected with 12.
Lordship, we are appealing for the 12th. Lordship. This matter has already been admitted, Lord, for a different bank.
No,
Lordship,
12 is also connected.
But Lordship, this subject matter is different. Lordship may kindly segregate.
Let me segregate.
12, you are also appearing in 12.
No, my lord. Now the brief is with them.
Okay, okay.
If I'm appearing, why all of them are covered? So, to segregate them can be done.
No, if it's
That's why-
covered, what is the point of adjourning this matter?
So perhaps some difficulty has been expressed. So I have
Okay, so some difficulty. Well, when do you want?
My lord, as far as item 13 and 14 is concerned, with these two matters may be listed on 25 4 or 34 mil.
25-4? Okay.
Along with WPC number 2307 of 14 mil.
14?
Yes, 2307 of 14.
Okay. So for item number 12, huh?
13 and
Also 7. 12, what is your prayer?
Lordship, the matter may be segregated.
No,
Lordship,
that is
for
okay.
a
When
week-
do you want
in
listed?
the first week of April.
Today?
first week of April, I have some.
Today? What is the difficulty today? The
Today
old
there is
matter.
some difficulty. We are being led by Dr. Saraf in this. Yes.
Okay, well, tell us the date then. It's a 19 matter.
Second week of April. Second week of
Tell us the date.
9th
9th of?
April.
Today is what?
Lordship, let it be on the.
Not
Very well.
9th of April. Not go after to the month of April. 19 matter. What are you saying, Mr. Counsel? We'll accommodate you definitely, but not like this. 1 month. On 21st.
21st.
Okay. And your matters?
25th or 30th.
25th.
Yes.
25th is a holiday, not possible.
30th
38th is a Saturday.
of 2000 April mil.
April, no.
We will be out of discussion.
Sorry.
I will be out of discussion.
Before the 21st is fine with me. Lord.
Do it today. 19 matter, we cannot adjourn for 2 months. Sorry, Mr. Kejriwal. We are making maintaining our standards. We'll accommodate you 1 or 2 days here and there. Maybe 1 week, 2 weeks. But not like this.
Let it be after 2 weeks as per the condition.
Give us date of your convenience.
19th of March, your Lord.
No, my lord.
We can have it on 21st of March.
Very well.
21st of March.
Along with
Oh, that will say. In item number 12, you write. Though this writ petition is listed with 2 other writ petitions, comma, it is submitted that the subject matter is different, full stop, para. Accordingly, this writ petition stands segregated to be listed on 21st of March for admission hearing, full stop. Considering that this matter is of the year 2019, comma, an endeavor would be made to dispose of this writ petition. Okay, and then 13 and 14 you write?
let these two matters be on 26.
20?
26.
26 is a holiday. 27th. 13 and 14. On the prayer of Sri S.K. Kejriwal, Sri S.K. Kejriwal Learned Counsel for the petitioners in these cases, prays for some accommodation, full stop. The para, these matters are of the year 2019, full stop para. Be that as it may, and in the interest of justice, accommodation is granted, directing listing of these matters on 27th, 27 4, along with full stop. List along with WPC 2307 of 2014. 14 matter?
Yes.
Why pending? 10 years? Along with 2307 2014. Okay.
Public.
And last admission, hearing, endeavor will be made to same line. Okay.
These are already admitted, my lord.
इनका नाम लिख लीजिए. Sri KP Pathak. Oh, these are already
Yes,
admitted.
my lord.
13 and what about 12?
That is also admitted.
12 was also
Admitted,
admitted. Last में मत लिखिए. एक line लिखिए. It is submitted that though these matters are listed under the admission column, comma, the writ petition एक में was होगा, एक में were होगा. Were admitted, were already admitted. Full stop para. Accordingly list for hearing.
Obliged.
On so and so date होगा. ठीक है? ये हो गया. 12 होगा 21st of March. 13 and 14 है 27th of March.
Obliged.
Is there any interim
I-
order? No.
Interim order is there, my lord, until further.
Yes.
Item number 51 to 57, I make the prayer on behalf of the state. Let it come up after a week, Lord. I
51
obtain the consent of the
My lord, interim order is there, my lord, that to be confirmed.
51 and 57. What are these
51
matters?
to 57. Lord.
Settlement of interim.
What about the private respondent? Taking the consent?
Yes, Lordship, I have.
Lordship, I am appearing for in item number 54 and 55. Lordship, may I pray that this matter may come after 3 weeks?
We'll fix a date after around
After Holy Lordship.
MS M. Devi, learned counsel, appearing on instruction of Sri Dinath,
Sure.
the learned senior government advocate Assam, prays for an adjournment in these matters. Full stop. Sri J.I. Borbuya, learned counsel for the petitioners, however, submits that there is an interim order which is required to be continued. Full stop para. List after 3 weeks. 3 weeks. Full stop. Para. Interim order passed earlier to continue till the next date of list. Interim order, if any. Passed earlier, if any, to be continued till next date of listing. 51 to 57. Okay.
Okay. May I please your Lordship? Lordship, I beg to mention item number 24. I am for the petitioner.
2-4.
Yes. Lordship,
Yes.
kindly attend the matter for the day. We have informed the standing counsel for the excise
Okay. When do you want?
after a week, Lordship, but not on 19th. Lordship.
What is your name, madam?
A. Agarwal, appearing
On-
on behalf of A. Petitioner.
On the prayer of Miss A. Agarwal, learned counsel, appearing on instruction of 3A Bhattacharya, learned counsel for the petitioner. Matter is adjourned to be listed after a week.
Right.
And later, Lordship, I beg to mention item number 38.
38,
38. With the consent of the advocate.
38. Okay. Yeah, for the petitioner.
No, Lordship, I am for respondent. I am on behalf of advocate.
Inform the petitioner on a prayer made on behalf of the respondents. Matter is adjourned by a week. Item number 30. Yes,
May it please the court. Item number 25.
yes.
Well, may I pray the matter be listed after the fully that part? Some instructors are required in this matter.
21 matter.
Well, fishery was settled with a school. We filed a writ petition. Interim was refused. We went in appeal. Appeal was allowed. Considering the law holding the field. Eventually it is decided, but what is the ground status? I do not know. It would be unfair on my part.
Oh, 2 weeks, not
2
after
weeks.
holy.
Obliged, sir.
Sri S. Bonik, learned counsel for the petitioner, submits that some time may be granted to obtain the latest instructions. Full stop para. List after a week.
After the week of 16 to 21st, I'm not in town. So therefore I was praying after the 14th. 27, 28 is so.
List after 2 weeks.
Obliged, sir.
May I please, Lordship? Lordship, I beg to mention item number 20.
20, yes.
Lordship, in this matter, the standing counsel for the respondent number 5 is out of station due to urgent.
Okay.
Lordship,
Who is respond number 5?
AI, Mr. AI,
You know, who is respond number 5?
Election Commission of India.
ECI, okay. When do you want? When do you want?
Kindly adjourn the matter for 1 week.
1 week. You inform the other side
Yes, time.
on a prayer made on behalf of the State Election Commission,
Election Commission of India.
ECI, Election Commission of India. Matter is adjourned by a week.
Yeah, prefer date.
Tell us. Matter is adjourned, full stop. No, don't say very weak. List on, yes, Mr. Kohli, when do you want? Which
19th.
date? Today is 6th. We'll have it on 15th. Okay? 15th is okay? 15th. 15th free.
Oblate.
Yeah.
Lordship, I beg to pray before item number 46, Lordship.
Hmm.
Lordship, on the last occasion, this honorable court direct has to trace out the name of the present income of the content number 3 and 4, Lordship.
Hmm.
Lordship, as per my inspection, Lordship, in respect of content number 3, after reorganizing by the irrigation department, the power vested upon the additional chief engineer has been transferred to the superintendent engineer, Lordship. And the concerned post of additional chief engineer has now abolished. Lordship, I may be allowed to impede this person, this three
It's
persons.
up to you whom do you implead. Without an application, we cannot pass any, we cannot make any comment. You, we grant you 2 weeks time. Your name D. Burman,
Yes, Lordship.
Sri D. Burman, learned counsel for the petitioner. Prays for some time to file appropriate application for impleadment, full stop. List after 2 weeks.
Highly observed, Lordship.
Mr. Burman, you are supposed to issue a notice before you file an impleadment application. Do that.
Yes.
If you need more time, we can grant you more time. Let it be after 4 weeks. You issued a notice prior to that, otherwise you'll not issue notice in the impleadment application unless you are satisfied that the person was notified of the order.
Yes, Lordship.
List after 4 weeks, yes.
Highly obliged.
Yeah, please, Your Lordship. Lordship, I would like to mention for item number 6 to 9,
Yes.
with the consent of the petitioner, we would like for an adjournment for the.
6 to 9.
yes,
6 to
item number
9 are old
6 to 9.
matters, madam.
6 to 9, Lordship, I am the petitioner. To involve is pending in court with Supreme Court.
You are mentioning on behalf of whom?
Respondent number 5.
Who is 5?
Net fee.
Net
John.
doesn't have much of a role.
Lordship, one matter that item number 6, Lordship, the net fee has some role there because the DLC has already cleared their claim.
Okay.
So now it is before the net fee. So net fee need to disperse the money. So I think because of
But
that.
NetFee, does NetFee have any role in the decision making process?
No, not in
No,
the.
it's
It's only a
on
nodal
dis-
agency.
Only the
On disbursement part.
dispersal, that's what.
So
Right,
that you're a formal party.
So I mean,
And the issue involved is for grant of interest for delayed payment.
that
That
is
is
already,
pending in Supreme Court.
Huh.
So I also say that matters may come up after 3 weeks. Or that is scheduled.
What about this?
that is pending. So Lordship, maybe.
And the main issue, otherwise the principal amount has been disbursed.
Yes, principal
In
member
item number 7, 8, 9, it has been disbursed.
dispersed.
6, it is remaining.
Six only remaining, that is with the net fee, but otherwise that.
6, what is the difficulty, Dr. Todi?
Principal amount is with net fee.
No, what is the difficulty expressed by them for not disbursing?
No, there was some miscommunication with the industries department. The respective documents were not forwarded at relevant point. of
Now, what
time.
is the stage, Mr. Kolta?
I mean, Justice Department has sent all the relevant documents of 8th of January. This day, 8th of
Okay,
January.
madam, you get the instructions regarding 6. 6 or 7?
So on the next
6.
date, they can.
Item 6.
Items.
Okay.
Next date, they
We
can
adjourn this matter, but so far as 6 is concerned, as far as the principal amount is concerned, you get it done. Okay. Item numbers
6, 7.
6, 7, 8, and 9. Okay. This court has been informed that the issue involved regarding interest on delayed payment. Was it delayed payment or interest on the amount claimed?
No, I mean, for.
Are you invoking that interest on delayed payment act?
No, no,
No.
do not.
So we'll not use those expressions. The issue involves a claim for interest on the amount which were paid to the petitioner, which were released to the petitioner after a considerable lapse of time. Full stop. It has, however, been informed that the issue is presently pending before the Honorable Supreme Court in, give the number, so and so, para. So far as WPC, 2319 2017 is concerned. We didn't record item number 6, na? Decline, yeah? This court has been informed that the principal amount is yet to be released by net fee. Full stop. Instructions, Sri A. Kolita, Learned Standing Council, Industries and Commerce Department, however, submits that there was some issue with regard to exchange of documents, which however has been completed in January 2024. Full stop.
8th of January,
8th of Jan, on 8th of January 2024. Para. The Learned Council may obtain necessary instructions regarding the issue of release of the principal amount in this case.
net fee council.
Next, even you will know, Mr. Todi.
Once
Okay, list these cases after 2 months. Para. However, in case there is a decision of the Honorable Supreme Court in the meantime,
Yes, at that,
Learned Council are given liberty to make a mention of this matter.
SLP number is 11056.
SLP 11056 11056 of
2020.
2020.
Ma'am. My lord, item number 39, I am 40.
Yes.
Because my scientific headstone for it. Item number 39. I have
Okay.
informed the other side.
I am for the respond number 7.
What is the matter?
Regarding settlement of small piper.
Okay. Any objection?
No, Lord, for 1
After a week,
Right.
on a prayer made on behalf of the petitioner, matter is adjourned by a week.
May I pay for a date? On
Don't say,
15th of
3A, no, don't write, huh? Pehla wala. 3A HMR Chaudhary, Learned Counsel for the petitioner, prays for an adjournment. Full stop para. List on 15th. 15th.
Oblige.
My lord, another prayer. Respect of item number 48.
Yes.
My lord, it says, my lord. Civil settlement going on. So matters taken up
48.
48 5 after 4 weeks.
What amicable settlement?
Because, my lord, dispute regarding the payment, my lord. With the
It's a contempt matter. If they have
Yes, my-
complied, it will close this.
no, my lord, one sitting has already been taken place, my lord. Last
Yes.
August, my lord.
3, item number 48. 3 AHMR Chaudhary, Learned Counsel, appearing for the petitioners, submits that there is some progress towards compliance of the order. And he accordingly prays for some time. Full stop para. List after 4 weeks.
Oblige. May I please, your lordship?
Have you informed the other side?
May I please, your lordship? Firstly, I beg to mention item number 44 and 45, lordship.
Yes.
In this case, lordship, new incumbent have been joined, lordship. So I take proper step, lordship.
Okay. Your name?
P. Sharma.
It is not there. Okay. It's there. Okay. Sri P. Sharma, Learned Counsel for the petitioner submits that there has been change of certain incumbents. And accordingly, he would like to file implement application. Full stop para. On his prayer, matters are adjourned by 4 weeks.
Oblige.
44 and 45.
44 and 45.
You are there in 44, 45?
No, my.
Item number 27, my lord.
My lord, I beg to mention item number 65, my lord.
Yes.
This item may be taken up at 2, my lord.
2 o'clock we have fixed the matter. We cannot assure. Partner matter is fixed at 2.
My lord,
65. What is the matter?
my lord, so more to contempt, my lord. On last occasion, my lord, they have submitted some incorrect statement.
Okay.
I'm
You do one thing. You come before. You have some difficulty now or what?
My lord,
We will take some time to reach 65. The last item.
my lord.
We'll take it up during the
Yes,
course of
sir.
the day. You come by around 12:45.
Yes, sir. Oblige.
Or maybe after 2:30, because the yesterday's matter is almost over, maybe around 15-20 minutes.
Fine.
Okay.
May I please, Lordship, item number 29.
29, yes.
Okay, Lordship, I am praying for 2 weeks time to file an affidavit. I've taken the consent of other.
You're for the other
No,
side.
no, no, he's not. Mrs. Soikia is there, and Soikia, I have spoken to her.
Okay,
I've
2 weeks.
spoken to her.
Please
2 weeks.
file it by 2 weeks, 21 matter. On the prayer of Sri A. Kolita, Learned Standing Council, Industries and Commerce Department, matter is adjourned by 2 weeks to enable filing of affidavit in opposition. No interim order.
No, it-
Okay.
Item number 27, my lord,
Yes.
to file a reply to the affidavit of the private respondent. I have taken the
Informed.
consent. I have
Informed.
taken the consent.
On the prayer of Sri P. Bharadwaj, Learned Counsel for the petitioner, matter is adjourned by 2 weeks to enable filing of rejoinder affidavit. No interim order.
Complete.
May please, Lord. Lordship, I am for the petition. I need some time to file reply.
Where was it? What,
In IA, Lord.
He's come up for the first time.
No, my lord, yes, Lordship, IA has come first time.
Oh.
I have only practice, my lord. I filed this IA on 20. I filed this at 226 3. 15 days time has already been over.
Listed for the first time today.
So it is there. Because
It may not be, it may not be that much. These are all, these are not mandatory in nature, directly. Recently also this Honorable Supreme Court has said,
given.
okay, but short time.
Yes, sir.
When did you receive this?
Yes, Lordship.
20
At
I
least you should have filed your reply. If it's not listed, different matter.
Actually,
Maybe the fault of the court, but where is your reply?
we already received instruction, but we are preparing the reply, but we.
Preparing is not enough. See, this is an ex parte or stay order.
Yes.
You know the consequence. Mr. Ahmed may be absolutely right in contending that 226(3) applies. At least there is no effort from your part to get this matter listed, get the stay order extended, or at least file a reply. You have not done.
20 I have the copy him. 120 I have him copy.
Sometime,
We are granting you time, that's a different matter, but don't take it for granted. Your name?
MS Alam.
MS Alam.
Yes, sir.
Heard Sri J. Ahmed, Learned Counsel for the applicant. Respond number?
8.
8, who by means of this application has paid for modification, vacation, alteration, sub-oblique, of the ex parte order dated 1/6/2023, passed in the connected WPC 3044 of 2023. Puttapara, Sri M.S. Alam, Learned Counsel for the opposite party petitioner, however, submits that the IA has been listed for the first time and accordingly prays for some time to file the objection affidavit. Full stop para. List on. Fix a date. We'll have it on 21st. File it.
Hello.
Thursday on 21/3/2024. Full stop para. For filing of objection affidavit. Full stop para. Interim order passed earlier stands extended till that date and would be reconsidered. Which should be reconsidered?
What am I declaring for?
For the BTC, okay, Sri
My parents also bring the record.
Okay.
On that
Sri
day.
Nayak, Learned Standing Council BTC is present.
Okay.
What is the matter?
Matter regarding settlement of Mahal. Their tender has been found defective, my lord. They are not submitting the required document.
And what is the tenure?
7 years.
7 years. Okay.
Published.
Mr. Nayak, I think record will cleanse the issue. Bring the records.
We are powered with the spend, because we are not the environment. Until that environment clearance transcript not. Subsequent transcript.
No, we already submitted. We already submitted environment clearance. We have NS here also. I already deposited the, they also take
Have
action.
you got the clearance?
Yes, got the clearance I have submitted. Because of interim order,
What is the ground of challenge?
grant of sale, they said their house has been there. But their tender has been rejected because they did not submit the registration number.
Okay.
That is why.
The quantum offered by the petitioner is more than you, but you say that is not a valid bid.
Yes, well, statement is
Only
there.
a valid, yours is the
I-
valid
I-
highest
I-
bidder.
I-
Okay, understood.
Only
Get the records, we'll-
only the
we'll-
clearance is there. I enacted that clearance also. I will never clear. I will have to be.
Lordship, till then, interim is there.
we have
Actually,
already said-
actually, interim may not be extended because they are not filed a petition. LWA.
You have to file a petition
Yeah,
also.
they are not filed. That is why
you are
interim may not be
neglecting.
extended, my lord.
At times you would be, I think message should go loud and clear.
Yes.
You have not filed objection, there is no application for extending the
Extension.
interim order. Matters were not that easy earlier. Mr. Ahmed have seen what was happening earlier.
Actually, since
At least you file an application for extension or passing of a fresh interim order if
Yes, yes.
14 days have passed away. That is
Yes.
the procedure. Okay.
4 and 5.
Please, your lordship.
15 matter, why listed?
Lordship, I pray for a short accommodation in this matter, my lord, as my senior, Mr. Ikuya, is out of station.
What is the matter?
Lordship, it is the non-payment of outstanding amount, my lord, to be paid by the respondent bank.
Nothing to do with the DP. We thought a disciplinary proceeding. Outstanding amount for what?
For the work order, my lord, there has been a work order.
You had done some work with the bank.
Yes,
You are claiming some amount.
yes.
How much is the amount?
Lordship,
Mr. Datta, why haven't you paid them? What is
no, my
the?
lord, the admitted part has already been paid.
Okay.
Only, my lord,
Remaining-
The
they want
admitted part is, was it a part of the subject matter or was it outside the
No.
purview?
within the parameters of the trust.
No. Writ petition was structured and filed in 2015.
Yes.
Did it include the entire part or only the unadmitted part?
So, no, what they want to say, my lord, I take my affidavit before your lordship.
Yes.
My lord, there are certain materials, they have said, they have used those materials, but after the verification, the architecture, he found that the less materials are given. And my lord, the difference is 87,000 only. And if your lordship may be convinced, my lord, if I take your lordship to that.
How much is your claim, madam?
Lordship, if lordship taking up the matter, then
We are not taking up, but we want to know the facts at least. And what is their
the
defense?
amount, my lord, was 18 lakhs 30,386, my lord, as per the
How much has been paid?
lordship, the remaining amount, my lord, is 6,63,826.
The balance, according to you,
Well,
yet to be paid.
Yes, my
That's
lord,
6
that
lakhs
has
amount.
been, my lord, confirmed by the bank authorities as well as the architect.
Mr. Datta,
No, firstly, my lord, my
was-
understanding is not posted with the all facts. Now, in their affidavit, they themselves say, my lord, the amount 17,43,108, this much has been paid. Now, the balance is only 87,000. These 87,000 balance, your lord, will see, after the verification architecture, he found that the materials used in certain areas, my lord, 3 or 4 items possibly. It was, my lord, I am giving one example.
okay, madam, when do you want?
What's the short date, my lord, on
15 matter.
uh,
We'll have it as soon as possible.
Yes,
Next,
yes, my lord, I am
next
ready.
Tuesday.
lordship on 15?
Next Tuesday.
Monday. Well, no, can it be on 15th, my lord?
Yes, my lord.
15th will be a
yes,
Friday. Difficult.
Yes, ma'am.
Let it be on 14th.
14, yes,
14th.
1-4.
Yes.
Thursday. We'll finish it off. 15 matter.
All right.
Okay. Mr. A.K. Bhuya is leading you or B. Bhuya?
AK Bhuyan.
Okay. A prayer for adjournment has been sought for on behalf of Sri A.K. Bhuya, learned counsel for the petitioner. Sri S. Dr. Learned Senior Counsel is present for the
Thanks.
United Bank of India, or I think
Punjab
it's, for the respondent bank. Para, considering that this writ petition is of the year 2015, comma, a short accommodation is granted, directing listing of this matter on 14th. Much. Okay.
Obliged.
And the other one,
Same.
Same color or the amount?
both.
May I please your lordship? Lordship, we need some time to reconstruct the file as this case has been newly handed over to us
Here for whom?
from RM Das,
For the water resource.
Water Resource.
None appears for the petitioner on call, whereas you are,
A Lodha.
whereas MS A. Lodha, learned counsel, appearing on instruction. No, A. Lodha, learned counsel, is present for the water resource department on behalf of Sri R.M. Das, the standing counsel, full stop para. On the previous occasion also, that is i.e. 16/11/2020, none had appeared for the petitioner, full stop para. In the interest of justice, a further opportunity is granted to the petitioner. Full stop para. List on March 11th, full stop. In case of further non-representation on behalf of the petitioner, comma, this court will pass consequential orders.
There is option.
Wait, please, Lordship.
Yes. Yes.
Lords, in the year 2012, an NIT was issued for retail outlet dealers in 114 locations. Accordingly, my location was serial number 49.
Okay.
After the 2012 NIT, when I submitted my
Mr. Mahanta, for whom?
correspondent 6,
6 is whom?
private respondent, who has
Okay.
been given the
Who
LOI.
is for the authority?
Mridal sir was there.
Okay, please call him. We'll take this for final disposal. Mr. Mahanta, please instruct your junior. Kindly try to call Mr.
That's my mistake. Accordingly, my lord,
Yes,
2012
please,
NIT.
please start from the scratch.
My lord.
Okay.
My lord's page number 2025 is the NIT that was issued.
An NIT was issued.
NIT
And
was
pay
issued.
date
11/7.
11/7/2012.
Yes, ma'am.
NIT by
For issuance of retail outlet dealers of IOC. My lord, setting up a petrol pump.
retail outlet
Yes,
of IOCL.
my lords.
Okay.
My lords, now,
This was the location was specified.
yes, my lords, that my location is at serial number 49. That is at page 21 at Jorhat, my lord.
The NIT starts at page 20.
Page 20, my lords.
At
21, serial number 49 is the location for which I have submitted my
49.
49 is the serial number, matlab for Jorhat.
Okay.
For there, I have submitted all the required documents.
Ji, Mo Bandha to Pulibor,
Matlab,
Jorhat.
yes. Serial number 49. Suppose that, my lord, annexure 2, my lord will find the application that I have submitted.
Where?
Page 26, my lord, annexure 2,
26.
26. This is the application that I have submitted.
Your application.
Yes, my lord.
Application. Is there any date?
My lord, this was submitted on 23/4/2012.
Where do you get the date?
That is at the bottom of the page number 26.
Okay,
Submitted on
23.
23/4/12.
It cannot be 4.
My lord, that might be 8, my lord.
It
Looks
should be 8
like 8.
because 11/7 is the
My
date
lord,
of the
my lord,
advertisement.
yes, it is 8.
Okay. Okay.
Post which, my lord, what has happened? On page number 34, this is important, my lord, because this was a reason why I was rejected, and that will come up later.
Your
My same documents, my
application
application
has been rejected.
My lord, I was
Yeah.
never issued an LOI.
No, your application was rejected.
Yes,
Why are you showing 34?
I'm showing 34 because the reason of rejecting my LOI was incapacity of showing funds. And these are the funds that
Where is
have-
the rejection order? In the chronology of events, after your application,
Yes,
you were
yes, I have.
issued this letter of rejection.
Yes, my lord.
Where is it?
My lords will find it at annexure 6, page 39. The rejection order dated 15/12/2017.
This is the impugned order.
This is the impugned order that will challenge to Posh
39, 15, 12,
2007.
70, 17.
17, my lords.
Why? After
My
so
lord,
many
what
years?
has happened that after 12, I have given representation because they did my field inspection also.
Hmm.
They have evaluated my application. Post that they did my field verification. And then it was a wait period of 5 years where I was kept in dark and there was no whisper as to who was given the LOI here. Well, I have given my representation also in the meantime. That is also the part of my petition. But that after that also I was not given any LOI or not. The response text was also issued. It was only 2018 that they were issued. My lord, 2007.
When did the private respondent started operation?
My lord, in the year 2018.
After this rejection
After
letter?
this rejection, then there was again re-evaluation.
But when did they really start the construction of the?
My lord, that respondent 6 might be able to say. Because we only have the documents pertaining to his grant of LOI. Now,
Yes, when did you start construction? You should know the facts. Senior will know the facts or you'll know the facts. When did you start constructing? It's not a supply job, it's a construction. You have to have a setup.
my lord. My lord,
Okay.
if I proceed. My lord, this page 39 will speak why I was rejected.
Mr. Mahanta, when did you start construction of your outlet? When did you start construction of your outlet?
Oh, no, that.
No, starting is different. Did you start construction? See, commissioning of a outlet is a different.
I know.
When did you start your business? We are not on the business. When did you start construction of your site, development, land filling,
As much as
boundary
I
wall?
can say, my lord, we have put a 30 lakh investment in the initial stage. If they could also say the same.
My lord,
Okay, please.
If I proceed.
Yes. Then after that, no, after you say that you applied on 23rd of August 2012.
My lord.
Thereafter, what happened?
Thereafter, my lord, a wait period of 5 years lapsed. There was no whisper as to who was getting this LOI.
5 years, there was nothing, no
nothing, my lord,
activities.
nothing. My lord should find my letter also to them. Because in the year 2012, I was given an interview call letter where I personally appeared, and after which my evaluation in 2012,
Show us.
minus annexure 4, page 36.
36.
That is 12/12/2012. That is my interview call letter.
After your application.
After my application, after my
So
verification, I was given it.
let us go chronologically.
Yes,
You
ma'am.
applied, then on 2012,
23.
you were called for interview.
Yes, ma'am. 12/12/2012,
Okay.
page 36.
You are Ajit Chandra Datta.
My lord.
Okay, then
Thereafter, in
when
2014,
was the date fixed?
for the interview, my lord, it was
2712.
27/12, my lord. Second line, it will be.
Yes, yes.
I
Interview
appeared accordingly, and my interview process was completed.
fixed on 27
2012.
at 12 noon.
Yes, ma'am.
Where?
It was fixed in the Tinsukia
Tinsukia.
Integrated Divisional Office, my lord.
Okay,
The address is on the third time.
got it.
Yes, ma'am.
You appeared.
Yes, ma'am.
Okay, then.
Then in 2014, I made an inquiry again. That is next page for itself. Page 37, annexure 5.
Yes.
That is the status of the inquiry of the retail outlet, that regarding my selection, as I was selected successful candidate for the retail outlet.
You were selected.
My lords, how this process goes is,
You wanted to know the
I
status
wanted
of
to
it.
know when my LOI would be issued so that I can begin my setup,
Okay.
which I already have done investment of land filling and boundary walls, but there's other technicalities involved, my lords, in this bit.
No, Mr. Singh, there would be one question.
Yes,
Before you go ahead with the land filling
Yes.
or any activities towards this business, you need to be offered with some kind of a communication or letter that you have been selected and would be offered the.
These are the letters, my lord. What happens is when they select you, they first evaluate you on certain parameters, which I'll come later. That is in the bid document. Once those parameters are met, they go for field inspection. Once the field inspection is met, they come for personal interview call. So I'm on the third stage, which itself proves that on first and second stage, I was being qualified.
No, like you, there will be other applicant also.
I believe, my lords. I believe.
So if you on your own volition make a huge investment without.
My lords, I'm not on that part
Okay.
yet.
Okay.
I'm just stating it before, my lords, that
Okay.
I've done my investment.
Okay.
Because capacity to pay funds speaks a lot about whether I have the capacity to proceed or not. And
You're in that context, that the
yes,
rejection is
yes,
on
that
the
I do have the capacity,
Okay.
and also I'll come up with
Okay,
other
okay.
documents.
Let us then you
Yes.
wrote a letter to know the status.
Yes.
What happened?
Nothing, my lord. In the year 2017, I was issued that my application has been rejected.
On the 39, page 39.
Yes, page 39. Straight away to 2017 from 12.
Please read
My lord, the first para says,
this page 37 letter of 2014 was not replied to.
in 2017, my lord,
Yes.
they have
Please,
written me a letter.
please read.
My lord, I read from para the point number 1. It refers, please refer to your application received for award of above mentioned retail outlet dealership. An interview held on 27/12/2012 at Tinsukia Divisional Office. Subsequently, field verification of your credentials was also conducted, but variations were observed under the parameter capacity to arrange funds.
Capability.
Capability to arrange funds, sorry, resulting in revised empanelment of results. Now, my lord, they have categorically got 3 stands on which they say that capacity to arrange fund has not been met. My lord, to which I have again replied to them on the next very letter, annexure 7, page 41, my lords.
But they have cited your bank.
Yes, my lords.
Details.
What they have done is, in the first, if my lord sees on 2A, they have
Yes.
cited me that I had balance of 15,345, whereas I have shown 20,345. But my lords, later on in my annexures, I've also put the bank statement, showed 7 lakhs of odd amount. That was a discrepancy, which could have been clarified, my lord, at that point. Other than that, the cash credit for the other shop that I'm holding, that is Miss Luca Fashions Put-ons showroom proprietor, that I'm the proprietor, my lords, and it shows cash credit facility, which I accept that it shows cash credit as debit, and that can be what their stand is, that this is not in the credit, so debit balance, I can come up with that. Because other than that, I have also given documents where I have furnished 70 lakhs odd amount promissory money that I would be given for development of this property by various banks. That is also part of my application. Yeah. In page 41, my lord.
But all these three,
Yes, my lord.
can you term this to be irrelevant or extraneous?
My lord, this is not
See,
the only ground.
Three accounts have been taken into consideration.
Yes.
Your savings account, you stated something, but the actual balance is something else.
Yes.
Number one. Number two, in the cash credit, there is a debit balance.
Yes, ma'am.
And in the last, so far, I think Gita, the developer,
My lord, this is
Gita
a
Wali Rajkumar.
family-run enterprise, but later on,
4,600.
yes, but later on it was terminated, and the whole I was the proprietor of this Gita Wali Kumari's Gita developers. So I was this proprietor. So this things could have been met in my application that I have given.
Okay, thereafter.
Thereafter, my lord, in 2017, I gave them a categorical reply to all the allegations that has been made. My lord will find it from page 42 that I have replied to.
41 is your reply.
41 is my reply, my lord. In page 42, I have stated that I would like to strongly deny and dispute a point stated in 2A, where according to balance of so-and-so amount and so-and-so amount, which is completely wrong, because according to our bank balance in 2012, it reflects 7,11,155, and I've also annexed my bank statement. So, my lords, for this entire operation, a 17 lakhs amount has to be shown completely. That is a part of their own issued document. Now, my lords, I have categorically replied into how they have discrepancies have been met to my capacity to arrange funds. Post which, my lords, what happened? I have given in page number 45, 47, 49, yes, ma'am, and 51. These are my sureties that shows that I have 70 lakhs odd amount to be received from friends and family, from bank and other financial institution, if at all my project proceeds with it, and I have the backing to complete. So capacity to arrange funds was never a question on my parameters.
Yes.
Yes, madam. My lords will pursue these letters and the affidavits. In page number 49, my lords, it has shown where Assam Gramin Bank has said that they are willing to extend a loan of 70 lakhs, fulfilling the bank norms and other things. Page number 49. In page number, again, 46 and 45, my friends and family has extended me 30 lakhs of loan amount. So, my lord, I had enough funds to proceed with this project itself. Now, this was the initial contention. Thereafter, I filed my RTI, knowing that what happened in this project and who was issued an LOI.
Where is the RTI?
My lord, in page number 56, my lord, seeking information.
56.
Yes, 56 and 58, my lord, because the initial was not replied to, so I issued another one with further questions. That is in page number 58. The two RTIs, my lord.
Okay.
Now, my lords, what happened is this entire bid has to be submitted in capacity, be it individual capacity, be it proprietorship, be it partnership, or be it HUF and other capacity. Respondent 6, who has been awarded the LOI, he has given his applications in individual capacity. But now what has happened, and if my lords will be in page 60 with me, page number 60 of my writ petition.
Yes.
There's a deed of lease, my lords.
Yes.
Where this property, my lord, this would be required because after which I'll come to the evaluation process by which they have awarded me marks.
Okay.
That is why this would be important later. My lords. This deed of lease, it is between.
No, Mr. Singh,
Yes.
let us be very clear. First, you have to overcome your burden.
My lords.
You have to establish that you were in the zone of consideration.
My lords, I was.
No. First, you have to overcome that. Then you can criticize or challenge the selection of the other,
Hello?
unless your rejection is successfully you can overcome. We may not go to the aspect of his credentials.
Hello,
At the behest of a person who
I understand.
you concentrate on your.
My lords, why I say so, I was in the
We'll,
zone of
we'll have
consideration.
we'll have the views of Mr.
Yes.
Bharadwaj. He is the main person who has declared you to be
Yes, sir.
unfit.
Yes.
Okay.
Why I say I was in the zone of consideration, my lords, because there were two initial evaluations held with my regard, where I was given different marks on both the stands. Now, if my lords, my second stance, which I'll come later on the documents of this purpose, on the revaluation part, I was not given marks with regard to cash credit, one zone, and another is properties that I have pulled. Earlier, I was given full marks, my lords, for that. But on the second evaluation process, I was not given marks. Itself, it shows, my lord, when my evaluation was done in the first process, they have seen my property, it met all the qualifications.
Where is the first evaluation?
But for that, my lord have to take the affidavit in opposition. If my lord's on the running page, page number 120.
Affidavit in opposition.
Yeah.
Or reply affidavit? Which
No,
one?
affidavit of in opposition.
By whom?
By the IOC.
Okay.
In that page number 120, my lord's running page, I believe. Otherwise, it is annexure R5.
120.
120. Why show this, my lord?
Just
Because
a minute.
it's
120, yes.
Yes. My lord, is this the Indian Oil Corporation note sheet?
2412.
2412, my lords. 2014.
It's a, yes,
Yes,
not shit, yes.
My lords, we'll see that it consists of two candidates, that is in number serial 3, Ajit Chandra Datta and Paramananda Fukan.
Who is Parananda Fukan?
In
R6.
serial number
R6.
R6, my lords, the private response.
R6.
Yes.
And you are Ajit Datta
Yes, my
petitioner.
lords. I'm the petitioner.
Okay. Okay.
My lords, next very page, that
Yes.
is page number 121, in the same note sheet,
Yes.
para 8, my lords, if I may. As per the requirement of the advertisement, estimated investment required from applicant for operating the RO was 17 lakhs,
Yes.
which will be considered for evaluating the candidate under the parameters capacity to arrange funds. Total marks for the parameter is 25, and the allocation of marks under this head is given below. The first is
Yes.
liquid cash in form 12 marks, fixed and movable assets 4, income on 4, and yes. And in para 9, candidate Shri Ajit Chandra Datta was given 16 marks out of 20 under the head of readily availability of finance. The next video.
Yes.
Then they reevaluated, my lords.
Yes.
Page number 123, my lords, is the reevaluation. The next very page. 123.
Yes. Petitioner got 16 marks. You got 16 out of 20.
No, my lords, I was given 0.
No. In 121,
In 121, yes, my lords.
you got 16. What is
Yes.
this 20? The table is of 25 marks. What is this 20 about?
My lord, this is,
Ready availability of finance.
yes, my lords. Ready availability of
This is
funds, my lord.
given 24, 4, 6. Oh, total marks, full marks. Oh, no, you're given
Oh, my
16.
lords. Yes.
16.
Yes, 60.
16 out of 20. 20 under
The capacity to provide finance.
ready availability of finance.
Fund.
Finance.
Then they reevaluate.
Where's the revaluation?
The next video.
Next page.
Yes, 2016. So if I read, L1 committee report on revaluation of applications pertaining to selection of retail outlet dealership at location so-and-so at Jorhat under this open. The marks by the L1 committee constituted by approval number so-and-so for revaluation is attached here with this revaluation. Next page, 123. Now, my lords, here I have been given in the second capacity to provide finance where the total mark is 25. I've been given 5 marks, my lords, total. And also, my lords, why I was saying that land criteria was important, because, my lord, here the marking system for land is also there, where an individual has to give his own land, whereas the private respondent has given the land, which is under lease, and he has also given a partnership deed, my lords. And also the term
Please come to page, this particular page,
123.
123.
Yes, my lord. Here, my lords, if I go with the marking system,
Yes.
the second column, my lords, with a liquid cash in form of bank balance, fixed deposit, shares of listed so and so marks, I've been given 0. Then fixed assets or movable assets, including so and so, where I have given my own property, my lords, where they've done the revaluation, I've given again 0.
Yes.
Only in the letter of ensuring loans, credit worthiness, and certificates have been given
You
5.
got 9. That means 5 plus 4.
Yes, that is on income, my lords. I got 9.
Income comes under the capacity to
Yes, ma'am.
provide
Yes.
finance.
I've got 9. Earlier 16, now 9.
And you got 9.
Yes.
Okay.
My lords, why I say this is because
Just a minute, please.
Yes.
7. What is the difference between you and the ours?
he got
6?
74, I got 68, my lord.
68.97.
Yes. My lord, for a moment, if my lord is on the first column also.
59, 70, 74.
For a moment, my lord.
Just a minute. If you are given 16, then you could have perhaps scored more marks than him.
Yes. And also with regard to the land requirement.
Difference is 6.
Yes. Also with regard to land requirement, that is a part of their own bid documents terms, my lord, which I'll come later, my lord. Now, for a moment, if the first is considered, my lord, that is the marks awarded for land evolution.
Yes.
That is the 100 marks total. I'm given 91. And private respondent has been 89, my lord.
Yes.
My lord, now the difference is nearly of 2 marks here. My lords, what I say here is that the private respondent has given the properties which are disputed and their title suits are pending. There are no NOCs to this regard from the other family members of the properties that they hold. My lord, this 89 cannot be also awarded because he did not give those properties in private individual capacity. He gave it in a partnership capacity, which is a part of my writ petition's final document, my lord. That is what I was showing. Now, if considering zone of my consideration, my lords, I have provided my own property, I have provided securities, but still I'm getting less marks in the next revaluation process. For a moment, my lords, if we go to the bid document, it starts from running page, my lords. '80. That is the brochure for selection of the dealers, my lords.
Just a minute.
Yes.
Bid document is at page
80, my lords. That is
80.
80. Running page.
Yes, please.
Yes, it starts from there, my lords.
Yes.
Yes, ma'am. Now, for a moment, my lords, maybe on page 85, the same part of it. It speaks about relationship clause for individual, including partnerships.
85.
Yes.
Yes. What is there?
85, it consists of family unit, my lords, where none of the individuals would be entitled to new dealership Oil India in any other individual in the family unit.
Clause.
Clause 6, subclause 1, my lords.
Relationship clause.
Yes, my lord. I just want to brush it up and read for my lord.
Yes.
None of these individuals would be entitled to new dealership distributionship of any oil company if any other individual in the family unit already holds a dealership distribution or letter of intent for dealership distribution of any oil company. This is one of the amendments that has been brought by the IOC, which does not sustain here because they have not been able to show that I hold any such other retail outlets, my lord. But since it was there, I have to read it out before my lord. Next it comes, my lord.
No, where
Page
has,
95.
IOC cited this as one of the reasons?
My lord, in the affidavits, my lord.
They will not go to this.
My lord, I'll come to page 95
See,
now.
there is a communication to you which says that your bid has been rejected on a particular ground.
Yes.
We will examine the legality correctness of that ground.
My lord,
Will not go to the any other grounds which are not, it does not find place in the order.
my lord, my final place, if I would say, page 95, my
You
lord.
can take this in your rejoinder, but rest assured, will not allow the authorities
I'll
to take
just
up any
read
other
this
ground.
last
Yes.
clause, my lords, and
Yes.
then I'll rest. Page 95, my lords. Same pen doc.
95.
Running doc. Page.
95.
Yes.
Yes, please.
Clause 14, my lord.
Hmm.
It speaks about evaluation of the site offered by the applicants. Point number A, owned land. Since
Yes.
availability of the suitable land for setting up of retail outlets at the advertised location is the essence of the project, whenever IC has advertised that it also needs land at advertised locations, applicants who readily have suitable site available for setting up retail outlets or have a firm commitment from the landowners for the purchase lease site, considering the location of the land from the point of view suitability from technical and commercial angle and rates acceptable to IOC. However, the land and details offered along with the application alone will be considered for this purpose, and the applicant will not be given the opportunity to offer any other land subsequent. For this important, my lord. For this purpose, the land owned by the family unit will also be considered as belongings to the applicant, subject to producing the consent or notarized affidavit signed by all concerned members of the family unit. This NOC and the affidavit for the land that has been submitted by the private respondents is not there. I speak so because there's already a pendency of suit where the other family members could not consent to such happenings, my lords. There.
Now, have they
Yes.
produced a
Yes.
notarized affidavit?
Yes.
They have.
They have.
Then-
I have brought it in on record, my lord.
No, if they have given a notarized certificate or an affidavit signed by the concerned members of the family, that they do not have
My
any.
lords, the LOI that has been awarded specific dark numbers. Now, these dark numbers are also a part of the land which they have leased from another person, and making this whole lease and getting this obtaining of land, they have also executed partnership agreement, which only after filing of a writ petition was terminated by them, that is accepted by them. But my lords, later on, the family members of the land, they have given a letter that pendency of suit, and they have not
No, see,
authorized for opening of IOC unit.
Mr. Singh, read the fourth line of own land.
Yes, my lord.
Suitable site available for retail, setting up the retail outlet, page 95.
Yes, my lord.
Retail outlet or have a firm commitment from the landowner for purchase lease. So lease as such is not barred.
It's not barred, my
It
lord.
is contemplated.
Then capacity to participate should be in individual capacity, because the lease, I am not barring on the lease, my lords. They can have a property on lease and open their IOC unit, but it has to have the consent of the other family members
Yes.
of the property.
We'll
That
see
is
from
not-
the records whether earlier other family.
That is what was observed in the last occasion.
Okay. Your contention is that there is no.
It is not
no
their land.
consent.
It is disputed land. Title suit has been pending on that land, and there is no NOC from the other family members consenting to open a dealer outlet here. Well, it's my
Okay.
contention to the revolution,
Yes.
the point on which they have been given the award. Okay.
Yes.
The issue letter is quite clear, madam. He didn't have the right amount of balance. He was not financially capable as on the last date of submission of application. Some dates are crucial. Lordship, the advertisement was published on 11/7/2012.
Mr. Bharadwaj, see, there are certain criteria which one has to overcome to become eligible for to come within the zone of consideration. And there are certain criteria where you evaluate and give marks. And in the markings, the one who gets the highest is selected. Now, as per the impugned letter, you have rejected his bid on a particular issue. At the same time, we have come across two evaluations. We are not on the correctness of the evaluation at this stage, but while evaluating, you had allotted marks on that head also. He gets less marks or more marks, but in a given case, if he secures more marks ultimately than the private respondent, then he gets the offer. Now, is your decision based on a cancellation due to not meeting of a particular criterion, or is it because of securing less marks than the respondent was 6? That is one thing you have to clarify.
Here, the selection procedure is simple. It's the interview. Now, if he secures best mark, then he is out because there are only two candidates. The second one, but the first candidate.
So there is no can we presume that the moment you issue a call letter to an intending party asking him to face an interview, that means you have done the background check and you have come to a conclusion that he meets the eligibility criteria.
Land
The-
evaluation has been done, not financial.
No, but you have
Madam, I have
see,
attached the guidelines. The guidelines specifies the procedure.
see in the two evaluation which you have just
Yes.
been
That is the interview.
for yes
two interview.
interview, there is an evaluation of 24/12/2014.
Yes.
Correct? And
Yes.
one is of 19/10/2016.
Yes.
We are yet to get to the issue of what was the reason to have two evaluation process.
Yes.
But we find that you have allotted marks on different heads to both the competitors. And ultimately he gets less mark.
Yes.
And therefore your justification that you have given to
Yes.
Mr. Mohanto's client.
Yes.
But the rejection order which has been issued by you
Yes.
is on a very specific ground that he does not have the capability to arrange funds.
Yes.
And to demonstrate them that ground, you have cited three reasons.
Yes. In the re-evaluation process, where the interview was taken once again. Lordship, kindly come, that entire record I have annexed, that entire, this is based on a
Now,
complaint.
did you hold him to be eligible for participation or not?
My lord, we issue call letters, someone files, we issue an advertisement, someone files application, we issue call letters saying that you have to come for you have to be present on so and so date for your land evaluation, the plot which you have offered.
Okay, okay.
All the rest of the criteria are fulfilled by documents annexed in the application.
Okay.
So we visit the plot, we do an evaluation of the plot which he has offered. That once that is done of all the applicants, then we call all of them to an interview. In the interview, we go through all those documents which he has submitted, which he has sworn also, saying that these all are true. On
See,
the,
27/12/2012, you had held the interview,
yes,
correct?
Yes.
Call letter is dated 12/12. You had called the intending bidders on 27/12. 27/12, you had the interview.
Yes.
You made the assessment.
Yes.
What did you find out?
Sir, he turned out to be number one candidate,
Number one.
number one.
Thereafter,
Thereafter, the complaint comes from the private respondent. The complaint, based on the complaint, we go for a re-evaluation. During the re-evaluation process, we find that whatever was stated in the complaint has turned out to be true. He didn't have the, under the head capability to provide finance. There are 25 marks, 5 is for credit,
yes.
but which is pure full mark. So remaining 20 marks, there we found that as on the last date of submission of application, he didn't have those amounts in his bank balance and all these three grounds we have taken in the interview, for which he was not given marks during the evaluation process. And he,
What about his, we'll come in details. He's making a categorical allegation that the land which has been
that
shown,
part,
that is
my
a
lord,
disputed.
that has been taken for the first time here.
No, did you get do you have the affidavits by the other owners? That is a part of the,
That's why the records were called, the records were not like.
doesn't matter.
But then again, my lord, that
We just want to know whether Mr. Mohanta's land, which is stated
Is
to be
under
a
dispute or not.
joint property.
whether
The
no objection has been taken.
co-owners have given affidavits or their consent. Is it there?
I can put.
Where is the note sheet? Even if you if you don't open the records, the note sheet, the original file will.
There's this deed sheet, my lord. Registered deed sheet between the private respondent and the owner. Both the owner.
As per number 6, land is a lease property. Lease property.
Long time,
Okay.
19 years.
Who are the owners?
Jagannath and Amar.
Deed of lease. What is your name, Mr. Mohanta? Paramananda Fukon. Where is your application, Mr. Singh, that this land is encumbered or maybe there are title suits pending?
My lords, my reply to the AIO that private respondent filed, my lord will file all the documents
No. What is the date of your application?
by date of application.
Regarding your date of the complaint?
Regarding the land that has been disputed, my lord. That only we came to know after the RTM, my lords. That is 2017, the letter of intent that was issued.
Then how can it be a subject matter of decision?
Because, my lords, the plot, if my lords will be on my writ petition last next year, that is a deed of partnership also. The deed of partnership specifically says that we'll be holding a land in lease. Whatever the profits would be coming, 80-20 would be divided into 2%. That is one of the leased owner. and the private respondent. And thereafter, they would proceed with this work, which they only terminated after the filing of a writ petition. In the meantime, this person has given in this individual capacity and shown this land in lease properties. Why I say it is disputed and why NOC is required, my lords? Because my reply to the affidavit in objection that is filed by response 6 shows the title suit that is in the dispute, where one of the owners has specifically written that to the IOC, page 160,
161.
160 and 161. It was.
One six zero,
Yes.
161.
Now, my lords, this is very clear that the plot on which they have taken this proposed petrol dealership that falls under dark number 391 and 392. Annexure 2, page 160, that is to the Chief Divisional Manager, IOC. One, Srimati Rajkumari Chetri has written an application for cancellation as they have not obtained NOC, this entire letter. And the next very page, page number 163.
This suit was instituted when?
2018, my lord. After file, but the NOC criteria is prior, my lord. It has to be obtained prior. The NOC needs to exist for giving a land for proposed petrol pump.
When the lease owners, the two owners of the land in question.
Unless the other owners. The other owners, that is what the title suit transpires.
Title suit of 2018.
My lord, I understand.
A material, a fact which was not even within their knowledge. Can you find fault with the decision-making process?
No, my lord. This was the other owners who have come into this lease deed. She existed always, my lords. This person, Rajkumari Chetri, she was always the owner of this property.
She did not manifest.
She did not manifest, my lords.
Her manifestation was made in the year, apparently in the year 2018, much after the decision-making process.
My lord, I came to know only in 2017 that there is a leased property that has. My lords, for a
You
moment.
cannot find fault with the decision-making process. We are examining the decision.
Yes.
Post events, the land may have a dispute later on.
Well,
Somebody might raise a dispute, but there was no dispute.
Well, 2012, the NIT was issued. They submitted the documents. And that point only NOC has to be submitted for a moment. It has to be submitted. 2017, they come up with my rejection that I cannot do it. Post which they have, 2018, they have given the petrol pump to this.
Which letter?
That is in page number 157, my lords. 2017, the private respondent were been awarded. That is the LOI. Well, that's why I say this, because already a 5 years whisper was not there for this entire process. And being one of the owner, this person was also in dark that this property has been given under lease and has been given.
The LOI is of 2017, 22/12.
Yes, ma'am. That's post which they started the work, and then only I came to know that there was a project that has been initiated, my lords. Otherwise, how a person would know, my lords, here? If I may know, my lords. My lords, 2012 I've submitted my documents, and this property has to be evaluated on all parameters where are there other owners who has given the NOC or not.
That cannot be a criteria for interference. Criteria for interference, you have to make out a case
my
that the
lords,
decision-making process was not lawful. Relevant factors have not been taken into consideration. Irrelevant factors taken into consideration. Here, there may be factors, but these are post. Now, if there is a dispute with the land, they'll raise.
My lord, then my double evaluation is always there, my lords. That I have been re-evaluated on two parameters after my submission of
no right accrued upon you. Was any letter issued to you?
My lords, there was no letter.
Some internal communication, then they acted upon a complaint. The evaluation has been done. And you're now criticizing their selection on the basis of a lease deed, and which you say that the land is disputed. The dispute came in the year 2018. that after issuance of the letter of LOI,
My lord,
even if before issuance of the letter of LOI, then also it will not be relevant because the decision, it is the date of the decision making which should be relevant for us.
my lord, but I have already given the capacity to arrange funds on different.
That is not
Now-
your own volition. We had asked whether any representation was given to you that yes, you would be offered.
I have been replying categorically
If
to
you
all.
try to bring in the concept of promissory estoppel, you have to make out a promise and that you have changed your position after the promise. Where is the promise?
My lord, that inducement, I believe, because the 5 years whisper was not there, that inducement of promises.
They can also take 5 years or whatever period.
My lord.
Does not give him any right, neither to you nor to him, unless the LOIs.
But my lord,
is-
what grounds they have taken for rejection that I did not have capacity in my accounts? I've given a bank statements where it shows that I had that capacity. That is a discrepancy that is offered, my lord. If my lord will kindly see.
His bank statement itself shows that he doesn't have that fund. He had just 4,000 rupees of that.
And Mr. Singh, unless you contend that these findings are perverse, your explanation may not be enough. Yes, there may be a malafide intention, in spite of you having sufficient funds which can be, which would be apparent from the materials which you have placed. It's ultimately your documents,
My lord.
your materials. They'll not make any discrete inquiry to the going to a bank. After, if they doubt, they can go. Even that is possible. But it is your document. Document shows that you do not have the funds at that time.
My lords, I have assured enough banks sureties on friends and family accounts and other bank assurances in the financial institutions, my lord. That also needs to be considered.
You should have given at that time.
My lord, that notarizations have been given, my lords.
Should have given the 3 documents.
My lord,
3 grounds.
my affidavits are 2012. That has been given as a part of my application.
The 3 grounds which they have cited to justify.
My lord, earlier they gave me 16 marks for that. On the re-evaluation, they gave me 0 for that. Whereas I've given my enough capacities to provide those funds also.
Now, on the complaint, before you took action, did you take his opinion or views?
No.
For the note sheet,
And where did you get the first evaluation?
My lord?
Was it communicated to you? No, it was not
No.
communicated.
It was 2014. I was only communicated in the year 2017.
No, first one.
I was not.
Difficult. Mr. Mahanta, anything?
My lord, in 2017, if you order is concerned, that's very clear, my. The lordship kindly see, my lord, his bank balance only is 4,000, my. And cash credit amount is, my lord, it is not a asset, my. Cash credit is, my lord, that is always debit balance. So, my lord,
That is not cash credit, it is debit balance.
My lord.
Credit.
So that's why an impugn, my lord, decision is, my lord, absolutely, my lord, taken into consideration by the authority, considering all the documents, my lord.
But can you go ahead with your project now? Your land
Already I have, my lord, already I have my, I'm in my affidavit. I have
but your land is now under dispute.
No, that, my lord, already, my lord, the letter was sanctioned to me, and I have already developed, and 30 lakhs I have already spent, my lord, for developing that land, my lord. Now, somebody on some behalf, my lord, maybe claiming that I'm also one of the head. After that, my lord, that was agreement was made in 2012.
You have also made 30 lakhs.
My lord, I have made my statement, my lord. Yes.
Where? Page?
No, not that. Para 11, my lord,
Of
my affidavit. Para 11. Para 11 of my affidavit, because in that page, my lord, internal page is 4, my lord, and running page I have not noted out, my lord, because at that point, I mean, it was not required, my lord. 2018,
now it is required. You should have.
now it is required, my lord. That's correct, my lord.
Okay. When did you file your affidavit?
I filed my affidavit on, my lord, 1/10/2020, 2018.
Okay, I think we have got your affidavit.
152.
Page
Page 1, probably 133. My lord, 133.
133.
The para
130
11,
is the affidavit in opposition.
my lord, 133 page, my lord, 11 para is here, my lord.
133. 11.
With regard to the amendment made in paragraph 15 of the writ petition, the deponent stated that after observing variation under the parameter capability of finance during the field verification of the first compelled candidate, IOC authority revised the compiled result of letter issued on 22/12/2017 in favor of not petitioner, in favor of the deponent. I'm sorry, my lord, the printing, my lord, typing mistake, and deponent. Only thereafter, present writ petition has been filed by the present writ petitioner with his ulterior motive and malignant motive to harass the deponent.
See, you had made investment of not 30 lakhs, 35 lakhs.
35 lakhs.
Why did you miss out 5 lakhs?
Sorry, my lord. No, he said that he 30 lakh, I denied.
No, you said even now.
No,
last time.
I 35 lakh. He said in that
You-
petition that he
You
has.
said he also made 30 lakhs.
Yes.
You're not very sure.
They already.
Or maybe
subject development is
35
highly
lakhs doesn't
developed,
mean
but-
anything
no,
to you.
My lord, sorry. He said that he has invested 30 lakh. I denied that, my lord. And rupees 2 lakh 6 before the Ministry of Road Transport and Highway Government. This is my payments.
Not a fit case, Mr. Singh. Otherwise, we would have done something.
My lords,
Okay.
why to the, if that can only be again be considered, my lord.
Heard Sri J. Singh, learned counsel for the petitioner. Also heard Sri P. Bharadwaj, learned standing counsel, IOC, who has also produced the records. Full stop. Response number 6 is represented by Sri T. J. Mahanta, learned senior counsel, assisted by Ms. P. P. Das. Full stop. Para. The subject matter of challenge, please have your seat. The subject matter of challenge is a communication dated 15/12/2017, whereby the application of the petitioner made towards an invitation to offer by the IOCL for allotment of a retail outlet at Jorhat has been rejected. Full stop. Para. The facts may be briefly narrated as follows. Para. The IOCL had published an NIT on 11/7/2012 for allotment of retail outlet in various locations, including the location of Moubandha to Pulibor in the district of Jorhat against serial number 49. Full stop. According to the petitioner, comma, he being eligible had applied for the aforesaid allotment vide an application dated 23/8/2012. Full stop. Pursuant thereto, comma, a call letter was issued to the petitioner on 12/12/2012, fixing the date of interview on 27/12/2012 at 12 noon in the office of the respondent at Tinsukia, in which the petitioner had appeared. Full stop. Since there was no response for a long time, comma, on 19/12/2014, the petitioner had issued a communication to the respondent authorities to know the status of the evaluation. Full stop. However, long after about 5 years, comma, the impugned communication dated 15/12/2017 has been issued, as per which the application of the petitioner was informed to have been rejected. Full stop. The principal reason cited for rejection was that the petitioner was not found eligible on the parameter within inverted comma, capability to arrange finance. Full stop. Immediately on receipt of this letter, comma, the petitioner had filed a representation on 22/12/2017, whereby it was informed to the authorities that the reasons cited were not correct and he was financially sound. Full stop. However, the petitioner came to know later on that on 22/12/2017, the LOI was issued in favor of the respondent number 6 without considering his case. Full stop. Para. Receiving the learned counsel for the petitioner has submitted that the reasons cited in the impugned letter dated 15/12/2017 are unsustainable in law and has been done without any application of mind. Full stop. Attention of this court has been drawn to certain annexures, including communication by the bank, as per which, comma, as per which it is claimed that the financial health of the petitioner was sound and he was in a capacity to run the business if allotted to him. Full stop. The petitioner had also procured certain information and documents by taking aid of the Right to Information Act. Full stop. In his affidavit in reply, by referring to the affidavit in opposition filed by the respondent IOCL dated 12/6/2018, comma, receiving the learned counsel for the petitioner submits that it appears from the note sheet dated 24/12/2014 that at the first instance, comma, all the documents and credentials of the petitioner was accepted and he was in fact evaluated against serial number 1, evaluated as the first nominee. Full stop. However, there was a second evaluation on 19/10/2016, as per which not only marks which were earlier allotted to the petitioner under certain heads have been reduced, comma, the respondent number 6 have been given marks under certain heads which was otherwise not entitled to by him. Full stop. Expressing by referring to the second evaluation documents dated 19/10/2016 has submitted that though the response number 6 has been given more marks in the under the heading land, comma, such land is disputed, and the ownership of such land is disputed, and there is also cases pending in the appropriate court. Full stop. He accordingly submits that while the rejection of the petitioner's bid is unsustainable, comma, the selection of the bid of the response number 6 is also not in accordance with law, and therefore there is a requirement of interference by this court. Full stop. It is specifically submitted that the NIT in question contains a specific clause, being clause 14, whereby preference would be given to applicants who would offer suitable lands, which would include family land. Full stop. However, the said condition is accompanied by a caveat that if the land is a family land, comma, the other co-owners would have to give necessary no objection certificates in the prescribed forms. Full stop. It is submitted that pendency of the case on the ownership of the land in question is itself a ground for rejection of the bid of the petitioner on account of on the head of land. Full stop. Para. P. Bharadwaj, Learned Counsel, Learned Standing Counsel, IOC, by producing the records, however, submits that the rejection order dated 15/12/2017 is a reasoned order, whereby the authorities in question had cited the reason for rejecting the bid application of the petitioner. Full stop. It is submitted that though in the initial evaluation made in December 2014, comma, the documents as it were submitted by the petitioner were taken into consideration, comma, no results of such evaluation was ever communicated to any of the parties. Full stop. In the meantime, complaints were received with regard to the financial soundness of the petitioner, and therefore the documents submitted by the petitioner were towards his financial health were reconsidered, and it was found that the first evaluation was done without taking the same into consideration in its proper perspective. Full stop. It is submitted that the second evaluation had to be done by taking into consideration the implication of the documents furnished by the petitioner towards his financial health. Full stop. It is submitted that under the parameter within inverted comma, capability to arrange finance, comma, 3 specific points have been taken in the impugned communication dated 15/12/2017,
I picked it.
which are all objective in nature, based on materials on record, and therefore this court may not interfere with such decision-making process, which is not vitiated by any mala fide. Full stop. Para. As regards the allegation made on the eligibility of the respondent number 6, comma, more specifically with his land documents, comma, it is submitted by Sri Bharadwaj that a bare perusal, that the aforesaid point was never urged in the writ petition and was only urged and was only taken in the affidavit in reply. Full stop. He submits that the documents submitted by the furnished by the respondent number 6 in support of his application were found to be meeting the requirements of the bid document, and the dispute and the land dispute which has been presently urged on behalf of the petitioner pertains to a title suit of the year 2018, which is much after the decision-making process and also after the issuance of the LOI, which is dated 22nd of December 2017. Full stop. The Learned Standing Council accordingly submits that the writ petition is liable to be dismissed. Full stop. Para. Sri T.J. Mahanta, Learned Senior Counsel, while endorsing the submission of Sri Bharadwaj, the Learned Standing Counsel of the corporation, has submitted that the rejection of the application of the petitioner via the impugned communication dated 15/12/2017 is based on objective criteria, wherein reasons have been cited. Full stop. It is submitted that none of the reasons are perverse and are rather based on materials on record. Full stop. Para. He reiterates the submission made on behalf of the corporation that at the time of that the alleged dispute with regard to the ownership of the land in question pertains to a suit filed in the year 2018, which will not have any effect in the decision-making process by the corporation. Full stop. Para. The rival submissions advanced have been considered, and the materials on record, including the original record placed before this court by the corporation, have been carefully examined. Full stop. Para. It transfers from the materials on record that the petitioner, along with the respondent number 6, had responded to the NIT dated 11/7/2012, in response to which, in respect of which, the parties were called for interview held on 27/12/2012. Full stop. Though the documents annexed in though the documents before this court would show that there was an initial evaluation on 24/12/2014, comma, there is nothing on record to show that such evaluation was, that the results of such evaluation was published or communicated to the parties, and therefore the question of accruing any right to either of the parties would not arise, as no such communication was made, full stop. This court has been apprised that certain more scrutiny was done on the credentials of the petitioner regarding his financial health, especially on the parameter within inverted capability to arrange finance. And thereafter, a second evaluation was made on 19/10/2016. Full stop. Based on the said evaluation, comma, the impugned rejection order dated 15/12/2017 has been issued to the petitioner, which cites 3 specific reasons on the ground of rejection, which are based on the parameter capability to arrange finance. Full stop. The impugned letter mentions that the balance in the savings account of the joint account of the petitioner was 15,345 as on 23/8/2012 as against 20,345 which was indicated by the petitioner. Full stop. It has also been mentioned that so far as the cash credit account of the proprietorship of the petitioner is concerned, comma, there was a debit balance of 2476605. And thirdly, in a current account, which the proprietor as Srimati Gitawali Rajkumar was shown as rupees 4647.50. Full stop. The said letter had also mentioned that in case of grievance of the petitioner regarding his rejection, comma, he could file a representation, which also appears representation, full stop. Para. The petitioner, the learned counsel for the petitioner has harped on this court is of the opinion that the reasons cited are germane and based on materials and records, which are also objective in nature, and therefore, unless the said reasons are shown to be perverse or not based on any materials on record, comma, this court would be loath in interfering with such decision-making process of the corporation. Full stop. Para. As regards the second leg of argument by which the petitioner has challenged the eligibility of the respondent number 6, more particularly on the land issue of the said respondent number 6, comma, this court has noticed that though it has been argued that the land in question is a disputed piece of land in which litigations are pending, comma, a perusal of the document filed in connection thereto, comma, it is found that the court case is in the form of a title suit, which was filed in the year 2018. That is much after the date of the decision-making process, as well as the date of issuance of the LOI, which is 22/12/2017. Full stop. Though a party to a list is entitled to bring in relevant facts, even by way of an rejoinder affidavit, as held by the Honorable Supreme Court in the case of 1963, wherein it has been held that averments made in a rejoinder affidavit would also be would also form part of the pleadings, comma. This court has noticed that even if those materials are taken into account, comma, those are found to be irrelevant for the decision-making process, which is the subject matter of challenge. Full stop. Para 3, seeing the learned counsel for the petitioner has submitted that he had made investment of a huge amount. Full stop. However, in absence of any materials to show that a right had accrued to the petitioner so as to drive him to make investment in this regard, comma, the concept of promissory estoppel would also not be applicable in the present case. Full stop. Para. In view of the aforesaid facts and circumstances, comma, this court is of the considered opinion that no case for interference is made out, and accordingly, the writ petition is dismissed. Full stop. Para. The records in original are returned back to the learned standing counsel. Any? Yes, we'll continue. 15.
Yeah, please, Your Lordship. My Lord, matter relates to a settlement of the mining permit area. Earlier, this mining permit area was settled with the petitioner for a period of 2 years.
Okay.
And he was directed to
file
obtain.
your pleadings. Okay. Yes, please.
My Lord,
Which is the
my Lord,
raise-
Lordship may come to page 35. This is the first letter of intent, my Lord.
you were found to be eligible and settled.
Yes, my Lord. That was settled and
Page
directed
35.
to deposit the security money of 2 lakhs to
What is the name of the mahal?
Nokhola Sen. Nokhola
Nokhola
Sen
Beach-
permit. Nokhola Beach Sen permit area.
Nokhula.
Yes, Nokhula, my Lord. N-A-K-H-U-L-A.
This is the settlement order, letter of intent.
Yes, letter of intent.
3,
For a period of 2 years, my Lord.
3/1/14.
Yes, 3/1/14, my Lord.
LOI, letter of intent. Nokhula. Two years.
Lord, what happens in this, by this order, my Lord, we are directed to obtain environmental clearance.
Yes.
And my Lord, that process is started, my Lord, from this T1/31/3/1/2014. Thereafter, my Lord, by next page, Lordship may come to page 36, my Lord. We are directed to deposit the kist money, first kist money.
Yes.
First kist money.
Hmm.
So accordingly, we have deposited. That is the next page, 37 page is that we have deposited.
You deposited. Okay.
But my Lord, environmental clearance was not obtained during this period. And ultimately, my Lord, on again page 38, my lord, lordship may come to.
Yes.
Environmental clearance, the Divisional Forest Officer directed the member, requested the member secretary, State Environment Impact Assessment Authority to issue the environmental clearance. Enclosing all required documents.
Yes.
Yes, my lord, directly, I mean, we come to the impugned page, my lord. What happens in this, my lord? The environmental clearance was not granted to the petitioner. Ultimately, my lord, lordship may come to page 47. That is the impugned order.
Not granted ultimately.
Not granted.
Okay. Page 47.
Page 47.
Yes.
There is the, my lord, by date order, my lord, Divisional Forest Officer
Yes.
forfeited the security money. Well, this is a common order for two mining permit areas.
Both were for you.
Yes, ma'am. And
And this-
in both the case, my lord, the environmental clearance was not granted. Accordingly, my lord, the security money was forfeited and he was blacklisted for a period of 5 years. The blacklisting period is already over.
Yes.
Against that order, my lord, we have submitted appeal petition also.
So
That
what
was
about the Mayong bit,
My
Mr.
lord?
Sharma? What about the Mayong bit?
Mayang with my lord. Actually, what happens at a relevant point of time, we filed one other petition, my lord. Lordship may come to that order also.
Disposed of?
Disposed of, my lord.
Same fate here also. What happened there?
That was disposed of in the said order, my lord. The honorable court set aside this
Blacklisting.
47,
Yes.
47 order.
Hmm.
Entire order
Forfeiture set aside.
Entire order was set aside.
So same you'll have here, same
And
benefit.
my lord, pursuant to the said order, my lord, they have complied with partially that security money of the Mayang bit has been returned.
This
Wow.
is yet to be. Mr.
But
Gogoi,
in
is
case
there-
of so and so, in case of the present of return matter. The another, my lord, we are aggrieved by another order lordship already seen, my lord. The first case money. Actually, my lord, environmental clearance is mandatory. So
Okay,
without
no,
environmental clearance,
understood. Yes, Mr. Gogoi.
so we are on, my lord, only return of money, man. Not on any.
Paying for this, this money.
No, first, we need not even go to the examining the legality validity. That has already been examined. Similarly situated, same petitioner Mayong set aside. But there is one more issue of refund of the kiss money. If he has not been able to operate the mahal because of an issue which is not within his hands, you took a penal measure that has already been interfered with this court.
Yes, Lord.
But what about the kiss money? It should be refunded to him.
This one, that's the contract money which he had submit. And furthermore, Lordship, he was never in agreement with the authority for running a mall. He even subletted the mall and FI was lodged against him. Lord. He subletted the mall. Environment clearance.
No, in absence of an environment clearance,
Yes, Lordship.
will subletting make the mahal operational? It cannot. Whether he sublets, runs on his own, until there is a environment clearance, you will not allow the mahal to be run by either him or his agents.
That's true, Your Lordship. We were personally insisting him to get the environmental clearance. But it never approached the authority for getting the clearance, Lord.
See, running it through somebody that will have penal consequences.
Yes,
You
sir,
take
Lord.
action. But how do you withhold the kiss money? He never.
That's a security money which he has deposited, Your Lordship, for running the mall. Thereafter, we asked him to get the environmental clearance as per this rule 38, Your Lord, 37, Your Lordship. Rule 37 clearly says that 37(2), the highest bidder shall be required to deposit an amount equal to 25% of annual debt rent, contract money, as a security, along with additional amount equal to 1 month's debt rent, contract money advance. That is deposited. Thereafter, we asked him to get the environment clearance. The delays have been made on his part. He never approached the authority for getting the environment clearance. Thereafter, there was no agreement between him and the authority for running the mahal.
No, Mr. Gogoi, see, it's very easy to make an allegation that he did not make any effort to get these. See, these are official matters.
Yes, sir.
And once a person expresses his interest to get a mahal, we cannot assume that he will just sit tight. He has invested some amount. He wants to do a business. And in spite of it, if the environment clearance is not coming, can we find fault on him? And thereafter, you forfeiting amount, that has already been answered by this court. We are not going to that issue. The kiss, how much was the kiss money?
This money is, my lord, 1,76,000.
Have you approached any court regarding unauthorized use?
We have
or
already lost an FIR lordship. We have taken an FIR.
thereafter?
Thereafter, status we have not known till now. But he's in his statement, he's making as far as environment clearance is concerned, I am on that.
What is the prayer?
Only for return of money.
Return of what money?
Refund of
Security
first
money as well as the, my lord, this money.
tax as a security money, earnest money, a lot.
My lord. Only for return of
379.
379.
How much is the for if you go
total 379.
if you go by the earlier order pertaining to Mayong, how much was the amount involved? Not
Already-
not the amount, the component of the amount.
129 return goods.
Security. I think
46.
Mr. Gogoi, the security amount has been specified in the impugned order. It is 2,02,000.
2 lakh.
So what is the other amount? Kiss money?
In the other case, my lord,
No.
It
In
is
this case
ma-
only, you are claiming an amount of 379, isn't
Yes.
Yes,
it?
the lordship.
And the security amount has been specified to be 2,22,000.
Yes.
So from where do you get the other amount?
177, 256, my lord.
Yes, what is that?
177, 256. Ekini milai pelai. 177, 256. sir.
Yes, right, 177 to 56. Well, where do you get that amount?
My lord, page
Page
36, my lord.
You can pay that.
1 lakhs, page 36, lord.
36. 36 is what?
Yes, my lord, that is, my lord, occupancy, kindly, column number 1, 2, 3, 4 column, first kiss money, 1,51,500. Then income tax is 3,788.
This comes to that
And
amount.
that together, my lord, 177 to
But Mr. Gogoi is stating that you had indulged in some illegal activities.
Yes,
no,
sir.
my lord. Actually, what happens
That
here,
is the-
whatever he has stated,
Have you filed rejoinder affidavit?
one rejoinder
Have
affidavit
you
I have
denied?
stated, my lord.
Have you denied?
My lord, one
Okay,
criminal
we'll do
case
one
was,
thing. We'll do one thing. We'll ask you to refund the security amount. And so far as the kiss money is concerned, 5 years period is already over. No declaration is required. But when we say something, so far as the kiss money is concerned, he'll file an application before you. You consider.
Yes,
And if you reject it, you have to cite reasons.
Yes, sir. Lord.
Okay. Heard Sri J. Sharma, learned counsel for the petitioner. Also heard Sri R. Gogoi, learned standing counsel, Forest Department, who submits that affidavit in opposition has also been filed on 30/11/2022. Full stop. Para. And a person to process initiated by the Forest Department. Please have your seat.
well,
For settlement of the Nakhula, NAKHULA beat sand permit area in the district of Nagaon, comma, the petitioner had participated, in which he was offered a letter of intent dated 3/1/2014, full stop, by the said communication, comma, the period of settlement was specified to be 2 years, and the petitioner was directed to obtain the environmental clearance, full stop. Simultaneously, vide a communication dated 13/2/2014, comma, the petitioner was directed to deposit the first kist money which the petitioner had deposited on 26/3/2014, full stop. However, it is the case of the petitioner that in spite of his best efforts, comma, the environmental clearance could not be obtained by him, full stop. Para, Sri Sharma, the learned counsel for the petitioner, has also referred to a communication dated 17/6/2014 issued by the Divisional Forest Officer comma, Nagaon Division to the Member Secretary, comma, State Environment Impact Assessment Authority, Assam, requesting for issuance of the environmental clearance. Full stop. However, even thereafter, no such clearance was issued, full stop. However, full stop. Ultimately, vide the impugned communication dated 12/1/2015 issued by the DFO, comma, the settlement was cancelled and the security amount was forfeited, including the imposition of a penalty of debarring the petitioner from participating in similar tender process for a period of 5 years. Full stop. Para. Sri Sharma, the learned counsel, has at the outset informed that the period of 5 years is already over, and therefore it is only the question of refund of the security amount as well as the kiss money, for which necessary orders are liable to be passed. Necessary directions are liable to be issued. Full stop. He has also, full stop. By referring to the impugned communication dated 12/1/2015, comma, Sri Sharma, the learned counsel, has submitted that the said order pertains to 2 areas of said permit. Full stop. He has informed this court that so far as the other area is concerned, namely Mayong Beach Sand Permit Area of 2014-16, wherein a similar action was taken, comma, the said action was the subject matter of challenge in WPC
1258.
1258.
My lord, relevant paragraph at
1258 of?
58 of 2015.
Have you annexed it?
Yes, my lord. Lordship may kindly see. Relevant paragraph, my
Which
lord,
was,
page 69.
which has been disposed of by this court on 31/1/2019,
19.
interfering with the aforesaid decision and directing refund of the security amount within a period of 2 months, full stop. It is submitted that the aforesaid direction was not the subject matter of any further challenge and has in fact been complied with in the meantime, full stop. Para. Sri Sharma accordingly submits that following the said direction, comma, a similar direction be issued so far as the present permit area is concerned, and a further direction be issued for refund of the first kissed amount which the petitioner had deposited pursuant to the communication of the department dated 13/2/2014. Para. Sri Gogoi, the learned standing counsel of the department, by referring to the affidavit in opposition dated so and so, paisa na abar 30%, dated so and so, dated 30/11/2022, has submitted that so far as the issue of refund of the security amount is concerned, comma, he will not join. So far as the aspect, so far as the aspect of, he will not join any issues as the said issue has been decided by this court in WPC 1258/2015, which has been referred to by the petitioner. Full stop. He has also submitted that the period of blacklisting is already over, and therefore this court need not go into the aspect of adjudication of the said matter. Full stop. So far as the claim for refund of the kissed amount is concerned, comma, Sri Gogoi, the learned standing counsel, however, raises a serious objection inasmuch as it is on record that the petitioner, in spite of not obtaining the environmental clearance, had operated the mahal by subletting it, in respect of which an FIR was lodged in the concerned PS and a case is pending against him. Full stop. He therefore submits that while he would not object to the prayer for refund of the security amount, comma, no such directions be issued for refund of the kiss money. Full stop. Para. The rival submissions of the learned counsel for the parties have been duly considered. Full stop. Para. The requirement of environmental clearance is a sine qua non for operating a sand mahal. Full stop. Such requirement is to be fulfilled by an intending lessee, in which necessary cooperation is also required from the department. Full stop. In the instant case, comma, it is seen that the DFO had also issued a communication on 17/6/2014 requesting for issuance of the environmental clearance certificate, which however was not done. Full stop. Accordingly, comma, full stop. This court has already observed that in absence of such environmental clearance certificate, comma, a mahal is not able to be operated. Full stop. Under such condition, comma, issuance of the letter dated 12/1/2015 by cancelling by not only cancelling the settlement, but also directing forfeiture of the security amount and blacklisting for 5 years does not prima facie appear to be justified at all, full stop para. In any case, comma, this court has already been informed that a coordinate bench of this court in WPC 1258 of 2015 has already interfered with such an action pertaining to the same petitioner so far as another mahal is concerned, which incidentally is a part of the present impugned communication dated 12/1/2015, full stop para. Accordingly, comma, there is absolutely no dispute at all with regard to the entitlement of the petitioner to get the security amount refunded to him, full stop. As regards the claim for refund of the kist amount, comma, this court has been informed that the petitioner had indulged in certain illegal activities by subletting the mahal in question, in respect of which an FIR was also lodged, full stop. Para. Taking into consideration the aforesaid facts and circumstances, comma, it is directed that so far as the security amount of rupees 2,02,000 is concerned, comma, the same be refunded to the petitioner within a period of 45 days from today, full stop. So far as the claim for refund of the kist amount is concerned, comma, considering though in a normal circumstances, comma, this court would have passed an order for consideration of such claim for refund, comma, in view of the existence of certain other facts which have been brought on record, including filing of an FIR, comma, this court directs the petitioner, this court permits the petitioner to file a detailed application claiming refund of the kist amount before the DFO Nagaon by a written representation, full stop. In the event such representation is filed, comma, the same is directed to be considered by a speaking order, which is to be done within a period of 45 days from the date of receipt of such representation, full stop. Writ petition accordingly so disposed of.
Alright.
Alright.
লিখিব লাগিব in normal circumstances for considering such application without any further observation, however subsequent. Yes.
16.
Sixteen. Forest, yes, was there.
Okay. Get up, like, pick up this matter you're talking.
Just a minute. None appears for the petitioner on call, whereas three R. Gogol and Standing Council Forest Department is present. Full stop. On the last occasion also, that is 8/12/2022, none had appeared for the petitioner. Full stop. Para. Be that as it may, and in the interest of justice, a further opportunity is granted to the petitioner. Full stop. Para. List accordingly on 11th of March 2024. Full stop. It is however made clear that in case of further non-appearance, non-representation, this court will pass consequential orders.
17.
Lordship, in this case, on the earlier occasion, I took time to file an affidavit in reply. It was in the month of April 2023, but due to some inadvertent mistake on my part, I could not file. I may be granted about 1 week time to file that.
19 matter, Mr.
Yes,
Tamboli,
Lordship. Lordship,
where in 2024.
Yes, Lord.
Inadvertence was last year,
Lordship, that was my mistake because I forgot somehow. due to
but
my
we'll not forget to have this matter today itself. No, we'll not give you time to file rejoinder.
Lordship, only 1 week time because
Sorry,
13 documents.
sorry, 19 matter, no adjournment on the issue of filing rejoinder. Sorry.
Lordship,
On
in this
personal
case,
issue, somebody is not well, then it is okay, but no.
Lordship, here certain documents I could not file is because those documents are vital.
It is up to
I have-
you why you did not file the 19 matter. We'll not
Lordship,
give
only-
you.
If
Sorry,
Lordship,
sorry,
then
sorry.
1 day.
Don't expect, don't make this kind of prayers. This bench is not for giving adjournment in 19 matters. Sorry. Argue your case or we'll take it up.
It was relating to the allotment of LPG Gramin distributorship in Kostumara NC of the parcel, and that was advertised in the year 2018.
27-5, 25-7,
Yes,
25-5.
25/5/2018. There was an advertisement for allotment.
Page
Lordship, this advertisement at page 13, annexure 1.
1-3.
Yes, Lordship. Then I applied for the post.
Just a minute. This was in Okhomia Protein.
Yes, Lordship.
This is for what? Appointment of LPG distributorship.
Gramin distributor.
Where do you get it?
Appointment of LPG Indian also
Ruban.
distributor. R urban Gramin the Durgam Kshatriya distributors. That is Gramin here.
LPG for Gramin distributorship.
Yes, Lordship.
Okay.
So there the eligibility criteria
Yes.
for selection of the eligibility for selection of the LPG distributorship requisite infrastructure of land for establishing the LPG godown, showroom land for ready inbuilt showroom, and then infrastructure for home delivery of the cylinders, etc. And detailed guideline for selection procedure has been set out in the LPG distributor selection brochure, and the same can be downloaded. This is the condition there. And
Yes.
Lordship, the conditions are the eligibility criteria that I have stated in the petition. That is at page 4. It's para 4 starts from page 3, and the relevant portion is the
Page 3.
page 3. It starts from page 3 of my
Yes.
petition,
Yes.
and the relevant portion is at page 4.
Page 4, yes.
Eligibility criteria for applicants. All applicants fulfilling the eligibility criteria will become eligible for draw for the selection of the LPG distributor. The eligibility criteria for the candidate to apply for the Sheheri Vitorok, urban Vitorok, Gramin Vitorok, and Durgam Kshatriya Vitorok are as follows.
Yes.
Common eligibility criteria.
Yes.
Applicant should be citizen of India and resident of India.
You did not read the whole. Which
Lordship, regarding the
which one are you connected?
para 5D.
5.
Para 5D. There is
Para 5.
D, that is the applicant's
5D. Page.
in the advertisement. page 4, BB. So Lordship, it is a pair. Page 4, para 5B. The applicant should have minimum 10th standard examination or equivalent from the recognized board.
Yes.
However, the criteria of educational qualification is not applicable to the applicants belonging to the freedom fighter category. This criteria was violated by the respondent.
Minimum
Number
10 standard. Minimum 10 standard. You said that the respondent number
Four.
4 did not meet.
Yes.
First, you say how were you rejected? You had applied,
Yes, Lord.
and you said did you qualify?
Lordship, I was qualified.
Where is the qualification?
And nowadays it is done by the drop.
No,
So-
to hold him eligible.
So, all the applicants filed their application. All of them are called for the drop. So in the lottery, this client was selected.
Thereafter, you make the other you verify the other credentials.
Then we go for the filtered
Okay. First, you have the draw lots.
based on the what they have submitted there.
Your R4 did not meet.
Lordship, in the affidavit that has not been stated in that manner. Lordship, in para 8 of my petition,
Now, what is your, Mr. Taboli, what is your case? That he has not passed, he does not have the minimum
educational qualification.
of being 10 standard.
Yes,
passed.
Lord.
Okay.
Initially, Lordship, what they are saying now is not the correct procedure. The procedure is that I have stated in the para 8 of my petition that the petitioner begs to state that the procedure for selection of the distributorship is by way of lucky draw from amongst the candidates found eligible in scrutiny amongst the candidates who fulfills the eligibility criteria set out as per the guideline. Against this para, they have stated that there is no comment. So that is the procedure. Initially, they will have to verify if we fulfill the eligibility criteria, then lucky draw
No,
is
your grounds of challenge will still be subject to scrutiny, because if you are making
Yes, Lord.
making a challenge that he is not eligible, whether he gets it by draw of lots, the initial selection, that will not make any difference. Ultimately, if he does not fulfill the educational qualification, he will not be considered.
Yes.
Now you make out your case. What have you stated towards
Lordship, in
respondent number
para
4?
11,
Yes.
I have stated that the application at the time, respondent number 4, at the time of submission of the online application made false declaration regarding her educational qualification and ownership of the landed property. So then I made a complaint. That was not
Yes.
considered.
Okay. Where have you stated paragraph?
Paragraph 11,
Page.
page 9.
Where false declaration?
Yes, Lordship. False declaration regarding the educational qualification and ownership of the landed property.
Yes.
Then I made a representation and that was not considered. That is why I
Where is your representation? 2510, 25:9.
yes, Lord.
Replied or not?
No.
Which is the page of 25:9, annexure 9, page 34?
Yes. Annexure 9.
No reply.
No, Lordship.
That is your only ground.
No, Lordship. Thereafter, now I have collected the documents that the school from that I could not submit that was I supposed to submit. Here, the RTI I came to know that the educational qualification, the certificate that he has submitted is false. Because at that time that school was not.
Okay. That is the only ground?
Yes.
Yes, what do you say, Mr. Bharadwaj?
So that first and foremost, we deny receipt of any
Complaint, okay. Now,
Yes.
there is a matter here. Here he has make a specific amendment that R4 does not meet the
Yes.
educational qualification.
Still, my lord, even non-receipt of the complaint, we have carried out the field verification. Your doctor will find it at page. My lord, the annexure T2, my lord, the second annexure to my.
Page,
T2, my lord, annexure. Fifty. 50.
50.
Annexure.
Why do you write P? No, no. You write A, B, C, D if he writes 1, 2, 3, 4. P because your P Bharadwaj.
No.
Maybe we thought that is the reason. Why not A, B, C, D, E, F, G, H, I, J, K, L, M, N, O? Then P. Yes. What is this?
My lord, regarding field verification of her educational qualification, my lord, we
Hmm.
write to the headmaster.
What is your name, Mr. Tamuli?
Aklima Khatun. Is Aklima Khatun, and the private respondent is the Kulmati Tesa. Kulmati.
R4 is
Kulmati Tesa.
Pulmoti. Yes, sir. R4. Okay. Yes, what is this? You have written to
we write
written
to
to
the-
R4.
Yes, we write to the, no matter. We write to the headmaster of Maulana Abul Kalam Azad High School,
Page?
page 55.
Okay, okay. 50 is what? Internal page what? Letter dated?
Well, annexure P.
P2.
Yes.
Okay.
To
P2. Yes, yes, we have got.
Yes.
To the headmaster.
the headmaster.
This is page 51.
Yes. Seeking verification
Yes,
of the educational qualification of the private respondent.
yes.
We write that she has submitted a school leaving certificate to her from your office of the headmaster, stating that she has completed and passed HLC exam in the year 1995 under roll number and 695
Yes,
number
yes.
14.
Yes.
So we received on the very next page, my lord, we received the reply. The type copy. The reply confirms. Reply confirms that according to your letter, I verified and found record that Fulmoti Nessa, daughter of Usman Ali, village Asamara, PH Asamara, district Borpeta, has appeared the HLC examination 1995 from the school under roll number 95, number 214, and passed her division. Thereafter, her mark sheet was also provided.
Okay, where?
Next to the reply.
Okay.
Mark sheet was also provided. This is from the Board of Secondary Education Assam. All the numbers are given. She secured 365 marks. But
Yes.
this is how we carry out the field verification. Even if a document is produced from a particular government office, we write to that particular government office
Okay.
whether that document is genuine or not. Not that go into the field,
Okay.
check whether
Okay.
it's
Okay.
Accordingly, the letter of intent was issued.
Where?
Was,
Page?
yes, again, my lord, annexure P1. Page, internal page 5 of my affidavit.
Yes.
This was issued on 12th of November 2018. And we have stated that the private respondent has started the construction of the Godam and the store. There,
This is letter of intent or
Yes.
what?
12, 11,
What do you call this? Letter of
letter of
intent?
intent. LOI. It is intended to offer you LPG.
This was of 18. What has happened now till now? Running.
Lordship, regarding this,
We'll come back. Yes, anything else, Mr. Bharadwaj?
But since my learned friend has based this case only on the educational qualification, I have subsequently that's why.
For the sake of his satisfaction, we'll have a look at the document. That's a different issue. Yes, what do you say?
Lordship, I have some.
This is item number? I hope
Yes, Lordship.
R4.
Yes, Lordship.
Yes.
Lordship. In
You have
our-
filed affidavit?
Yes, Lordship. They are already annexed, Lordship. In a
Page, dated,
Lordship, dated is
Fulmati.
Full-
Fulmati,
yes, Lordship.
14, 12. Yes,
Lordship, they are annexure A, Lordship.
of your affidavit.
Yes, Lordship.
Yes.
44 Lordship.
Annexure A.
A.
Yes,
It's birth certificate, Lordship.
yes, I hope. Just a minute.
Issued by the board.
Just a minute.
And next, Lordship,
Just a minute, 63. Yes. Pass certificate.
yes, Lord.
HSMC pass.
HL's path.
Yes.
Next page, Lordship, it's a, this is the transfer certificate issued by the concerned headmaster, Lordship. 10 pass. Yeah. Then Lordship, the mark take, whatever marks for 10.
Okay. Okay. Mark sheet. 68. Okay. Yes.
Lordship, then we filed one application, RTI application before the Board of Secondary Education and another before the headmaster. The headmaster of the Maulana Abul Kalam Azad High School has confirmed that the school runs from 1997 from class 5 to class 8. So there is in this year 1995, no student appeared in the HSLC examination in 1995. This is the given by the school. Then, Lordship, regarding this roll number, they are saying that her roll was 395 and number was 214. Now the SEBA has clarified the list of the candidate of the said school cannot be provided without proper roll code of the center of the school Maulana Abul Kalam Azad High School. It is found that Maulana Abul Kalam High School does not fall under roll N5395 as per the office record, and roll 214 is not found in the center code of N395 as the seen from the copy of the mark sheet.
You file a police case. You file a police case.
I have been working.
No, you file a police case. If you have these materials, file a police case. See, these are matters, you may have a very good case, Mr. Tamuli, but these are matters perhaps we'll not be able to adjudicate. Allegation of facts of fraud, which is essentially a matter of fact, you have to prove it. You file a police case, if these materials which you have obtained under RTI
Yes.
has some substance, file a police case. But here, see, on record, apart from the assertion made by Mr. Hawk regarding, he has given 3-4 documents. Let us, for the time being, assume that these are manufactured documents. There is a due diligence exercise made by IOC.
Lordship, here,
And IOC, after due diligence, have come. If you're going deeper into the aspect, you file a police case.
Lordship, IOC,
We'll leave that open for you.
Lordship, IOC ought to have verified that from the SEBA, the issuing authority, but they have verified from the
See,
headmaster where,
what the IOC has to do, it is up to the IOC's
because
discretion.
they will have to verify.
Mr. Tamuli, if no verification was done at all, we would have said, yes, you have done mechanically. Now, on the process of verification, I think this will be too much of you to expect that, no, this is not enough. If it appears that you have a good case on the allegation of fraud, you file an FIR. We'll leave it open to you. You could. Heard. Sri S.N. Tamuli, Learned Counsel for the petitioner. Also heard Sri P. Bharadwaj, Learned Standing Counsel, IOC. Whereas Sri I. Hawk, Learned Counsel, has appeared for the respondent number 4, full stop. The subject matter of challenge in this writ petition is the selection and allotment of LPG Gramin distributorship in the name of the respondent number 4. Full stop, para. As per the case projected, comma, a notice was published in the Okhomia Proceeding in its issue dated 25/5/2018 for allotment of LPG Gramin distributorship in various locations, including the present location at
Kostumara.
Kosumara in the district of Borpeta. Borpeta. Full stop. As per the eligibility criteria have been laid down, and one of the criterion is for a candidate is that the candidate should have a minimum qualification of 10th standard. Full stop. It is the specific case of the petitioner that though the respondent number 4 was selected by draw of lots and subsequently given the allotment, comma, she did not meet the said criterion. Full stop. Para. Sri Tamuli, the Learned Counsel, has submitted that having come to learn about such non-fulfillment of the eligibility criterion by the respondent number 4, comma, the petitioner had submitted a representation on 25/9/2018, which however was not responded to. And thereafter, he has filed this present writ petition, full stop. Additionally, the Learned Counsel submits that subsequent to filing of this petition, comma, he has also obtained certain documents from the competent authority by taking aid of the Right to Information Act, which would substantiate that the allegation made by the petitioner substantiate the allegation made, which would substantiate the allegation made by the petitioner. Full stop, para. Per contra, comma, Sri Bharadwaj, the Learned Standing Counsel of the corporation, at the outset has denied receipt of any representation. Full stop. The learned counsel, however, submits that in spite of the fact that no such representation has been received, comma, it is a part of the procedure prescribed to do a field verification with regard to the credentials of the candidates. Full stop. He clarifies that the candidates have to face a draw of lots, and the candidate who comes successful in such draw of lots, comma, his or her credentials are verified by the corporation, full stop. By drawing the attention of this court to the affidavit in opposition filed by the corporation on 30/5/2019, comma, Sri Bharadwaj has submitted that on 14/9/2018, comma, a communication was issued to the headmaster of the concerned school with regard to the for verifying the educational qualification of the respondent number 4, full stop. The said communication was responded to by the headmaster of the concerned school on 21/9/2018 by stating that the respondent number 4 had indeed passed the HSLC examination from the said school in the year 1995. Full stop. The corporation had also procured the mark sheet of the respondent number 4. Full stop. It is accordingly submitted that on 12/11/2018, the letter of intent was issued in favor of the respondent number 4. Full stop. Sri Bharadwaj submits that the foundation of the allegation is that there is no foundation of the allegation made by the petitioner, and therefore the writ petition ought to be dismissed. Full stop. Para. Endorsing the submission of Sri Bharadwaj, endorsing the submission of the corporation, comma, the learned counsel for the respondent number 4, Sri Hawk, has submitted that affidavit in opposition has been filed on 14/12/2022. Full stop. The learned counsel has referred to the HSLC pass certificate, comma, the transfer certificates, as well as mark sheet of the respondent number 4, and accordingly submits that the entire allegation has been made without any basis, and therefore the writ petition is required to be dismissed. Full stop. He further submits that in terms of the letter of intent dated 12/11/2018, comma, the respondent number 4 has started the business and is running the same without any hindrance. Full stop. Para. In his rejoinder, comma, Sri Tamuli, the learned counsel for the petitioner, has submitted that though time was granted to him by this court by the order dated 4/4/2023 to file rejoinder affidavit, comma, due to inadvertence, comma, such affidavit could not be filed. Full stop. He, however, submits that he is in possession of certain relevant documents which he had procured from the authorities by invoking the Right to Information Act. Full stop. He submits that one communication has been obtained from the SCBA and the other from
The headmaster, Maulana, here the high school.
of the headmaster of the concerned school, and both the communications, comma, as per the learned counsel for the petitioner, would show that the documents of the respondent number 4 prima facie are forged documents, full stop, para. The rival contentions have been considered, full stop. The writ petition was structured and presented with the allegation of the respondent number 4 not meeting the eligibility criterion of being a matriculate as per clause 4 of the advertisement dated 25/5/2018. Full stop. No documents as such were annexed to the said writ petition. Full stop. The aforesaid averments have been denied both by the corporation and the respondent number 4 in their respective affidavits in opposition. Full stop. Sri Bharadwaj, the learned counsel for the corporation, has clarified that irrespective of the fact of receipt of any complaint regarding the meeting of eligibility criteria by a selected candidate, comma, a field verification is done in every case, and in the present case also, comma, the relevant documents regarding the educational qualification were obtained from the headmaster of the concerned school. Full stop. The mark sheet of the matriculation examination of the respondent number 4 was also obtained. Full stop. He therefore submits that the allegation on which the present challenge has been structured prima facie appears to be based on prima facie appears to be without any foundation. Full stop. Para. The private respondent in her affidavit has not only annexed the HSLC pass certificate, has not only annexed the mark sheet and the transfer certificate, but has also annexed the HSLC pass certificate. Full stop. Under those circumstances, comma, this court is not in a position to accept the submission of the petitioner regarding the non-fulfillment of the eligibility criteria by the respondent number 4, mainly with regard to the educational qualification. Full stop. The Sri Tamuli has, however, strenuously contended that the documents which the petitioner has subsequently obtained would show that there is a foundation in the allegations made by the petitioner. Full stop. Para. Even if the said submission is considered, comma, an allegation of fraud perhaps cannot be gone into by this court, which is not a court of facts. Full stop. This court is only required to examine, scrutinize the decision-making process, and in the present decision-making process, comma, this court has found that the relevant factors have been taken into consideration, and an objective consideration on objective standards, and only after the verification exercise was done, comma, the letter of intent was issued on 12/11/2018. Full stop. Para. In view of the aforesaid facts and circumstances, comma, this court does not find any merit in the present writ petition, and accordingly the same is dismissed. Full stop. Para. Dismissal of the writ petition, however, shall not preclude the petitioner to approach the appropriate authority to for redressal of his grievance, wherein he claims to have been in possession of materials to substantiate the allegation of use of forged documents, full stop. It is, however, also clarified that in case such challenge is made, comma, the same has to be examined by the appropriate authority strictly in accordance with law and on its own merits. Writ petition stands dismissed.
Hello.
That we do not.
Yes.
Your Honor, I beg to mention item number
4-2.
42.
Yes.
We need instruction from the petitioner office that's why 2 weeks that may be granted. We have to taken the consent from the other court. The consent from the
It
editor.
of which year? Oh, 22 matter.
Yes.
Okay. What was this matter?
This any tender NIT was salient notice.
What is the challenge?
We have salient notice to specific terms in NIT dated 12/10/2022.
You have challenged certain terms of the NIT.
Yes, Your Honor. Specific.
When do you want? When do you want?
Yes, Honor.
When do you want?
We need instruction from that
No, no. When do you want?
after 2 weeks.
2 weeks. You have informed
Yes.
Agriculture Department.
Yes.
Okay. On the prayer of Ms. R. Dekar, learned counsel for the petitioner. Matter is adjourned by 2 weeks to enable her to obtain instructions.
Item number 71, it becoming out of
71.
just one supplementary list.
Supply list.
When he got the relief, non-payment of contractual fee.
Okay. Anyone of the finance from the finance department, elementary education department? Finance department? Who's there? Mr. Gogo is there? And elementary education, anybody who's in the court will record their name. Sri S. Bothakur, learned counsel for the petitioner, submits that the grievance of the petitioner has been redressed during the pendency of the writ petition. Full stop. He accordingly prays for withdrawing this writ petition. Full stop. Para. Also heard Sri B. Gogoi, learned standing counsel, finance, and Sri P. Bora, learned standing counsel, elementary education department. Full stop. Para. Writ petition is dismissed as not pressed.
Item 66. Pardon.
My lord, only one thing before my esteemed colleague begins. My only apprehension is if my lord enters into the merit of the argument pertaining to justification of the strike in the light of the settlement dated 15/10/2017, because the argument advanced is that the settlement dated 15/10/2017 does not cover the circumstances and facts due to which the strike was held. So, my lord, if lordship enters into the merit of that argument, then I will give a reply, because this is going to affect, not the other connected case. That's my worry.
No, that doesn't matter. Let us consider at least what Mr. Otherwise, you have almost concluded the.
Yes,
both
sir.
of you have
But
elaborated.
this reply I did not give. I never got the chance because, my lord, this was argued as a reply only. This was not the principal argument.
If there is any intention of this court to deal with that issue in a manner which might require a reply, we'll certainly hear.
It's not very- That's it. That's it.
Yesterday, your lordship was of the view that as so far the terms of refunds is concerned, so I just about the terms of refund. Your lordship was of the tentative view that this so far the refunds is concerned, I don't have any right to be to adjudicate. That was your lordship's tentative view.
No, no, we had said that the terms of the adjudication process will have to essentially be revolved and stick to the terms of the reference.
Definitely.
And at most incidental part, which is covered by 10.4, but what is incidental will depend on the facts and circumstances.
Yes, yes. So let's just page 19, first part of the award.
19.
19.
Yes.
The initial terms of reference was whether wages for the period of no work during the strike, public lockout is admissible to the workman. Subsequently, a corrigendum was issued.
Yes.
And by virtue of this corrigendum, the terms of reference was elaborated to some extent.
Yes.
Elaborated, modified. Elaborated is different.
Now, whether the workmen are entitled for wage during the period of strike from 27th November to 2007 to 29th November 2007. That is one issue. And for the period of lockout from 29th November 2017 to 24 July 2008. So your lordship's anxiety was that whether the terms of reference indicates whether the lockout or the strike is justified or not, there is no such terms of reference. And as I have understood, Lord, so the matter cannot be adjudicated upon without having that terms of reference specifically. Probably that was your lordship's question, query. Now, in that, in order to satisfy your lordship, Lord, I referred section 10.4. And your lordship, in that point, the scope of the code, so for the incidental matter is concerned, is very limited. It only can go to the extent of whether it is an incidental or not.
Yes.
So, Lord, in this regard, Lord, I would like to refer to the judgment.
Yes,
Lord.
please.
Sorry, Lord, it is an unreported judgment. I have to protect it. That is writ petition number 2601 of 2006. Judgment was delivered on 18/2/2009. Yes.
Yes.
Yes, right. I will give it. Now,
Paragraph.
let's straight away, Your Lordship, come to paragraph 2, the terms of reference.
Yes.
By
Yes, please.
notification dated such and such, let us keep it up.
Yes.
Now, the terms of reference is whether the action of the management of the NFLA Maligaon, Guwahati, by not absorbing Sri Shiva Prasad Bhattacharya, Sri D. Pathak, and Sri Ashok De in Group 3 post in the year 1991 is justified. If not, what relief the such and such are entitled. So our case was that in the year 1991-92, we were not at all eligible for absorption. So we acquired our right to be absorbed in the year 2000 only. The Industrial Tribunal passed an award as because there is no such reference, so we cannot pass any such award. Then I assailed this award before this honorable court, and this honorable court, while examining this aspect of this case, had gone to section 10.4, etc. Now, Your Lordship, straightway Your Lordship comes. Paragraph 4. In the case of the workman, as stated in the written statement, filed in that way, because before going to the detailed argument, what is my contention? That sometimes the terms of reference are not very clear. In order to fortify or in order to understand the terms of reference, the industrial adjudicator has to go through the respective pleadings.
And after going to the pleadings, they had to, it is something like framing of issues by the civil court. They had to frame the issues or understood this case, understood the case. No, no, paragraph 4.
Mr. Dasgupta, I think I might have a difference of opinion. This is a reference under 10. This is not an initial original application under 2A, where issues are framed after discussion of the pleadings. Here, the reference is already there. Parties need to file a written statement. Unlike 2A, where an aggrieved party files an application followed by a response by the other side.
No. I'm not going to that aspect.
What you had said that like a civil court, issues are need to be framed. Where is the question of framing issues?
No. I'm not on that. So what is your, let me clarify this. What your lordship wanted to know, that this is not a case under section 2A. When section 2A.
No, we had just given a passing reference that unlike a 2A application, which is akin to almost a civil proceedings, pleadings are there, then issues are framed based on the pleading. Here, issues have already been framed by the government, referred, and you need to file your response to the issue and matter adjudicate based on the evidence and materials on record. That's all.
Yes, sir, that I have understood. Now, this is a case which I am referring before you. Is a case under section 10.
Yes.
Refund. That is the terms of refund.
Yes.
Now, I will take some time.
Yes, please.
Paragraph 4, your lordship.
4, yes, we have read 4, yes.
In the case of the workmen, as stated in the written statement, 5 is that they were employees of Rongia Railway Consumer Cooperative Society, and they were appointed on 1982. The management of the State Cooperative Society. In the year 1995, a decision was taken by the management to demolish the building of the housing of the Cooperative Society. After the demolition of work had commenced, all the employees of the society, including the petitioners, were given leave without pay, with the condition that once the construction is completed, they will be called back to service. However, according to the workmen, they were not called back to the service, nor was the society dissolved. In the written statement filed, the workmen has further pleaded. In that year, that is 1991, the NFLO administration had taken up for the absorption of cases of a large number of employees working in the cooperative society, managed by the railways, and given the employment to such employees in defined categories in grade D service in the railways. However, at that point of time, this authority, the seniority position of the workmen concerned did not permit consideration of their case for absorption, for which reason the workmen were left out in the state process. It is the further case of the workmen, as pleaded in the written statement, that in the year 1999-2000, while considering the case of the absorption of the employees of the cooperative society, 3 workmen were excluded from such consideration, and in spite of the fact that they were eligible and entitled for such absorption. In such fact, a demand was raised by the workmen concerned for absorption in Group D post in railways, for which having been acceded by the conciliation. That is the case, Lord. In the year 1991, they have not acquired that right. They acquired their right in the year 2000, and so they raised this dispute. But so for the terms of reference is concerned, it is stated that whether they have the right as in the year 1991 or 1992, and industrial tribunal declined to pass an award. Now, Lord, again, your lordship comes to paragraph 5. The management in the written statement file contended that no process of absorption of the employees working in the cooperative society was undertaken in the year 1991-92, as claimed by the workmen. in their written statement filed. The management had further contended that the Rongia Railway Cooperative Society had become defunct and no business had been transacted in the state society since 1995. The workman therefore cannot deemed to be an employee under the society. In the written statement of the management had however admitted that the railway board by a decision contained in letter dated 2000, 35/2000 had undertaken in a process of absorption of the members of the staff of quasi-administrative offices, organization who were on the rolls of the continuously for a period at least 3 years as on 1997. That was the management case. And 1995 building was demolished, but we were all granted on leave with the condition that when the building will be constructed, then you will be resumed to take it. In the meantime, Lord, this has happened. We raised the industrial dispute, and this was the term of the reference. Now, Miller, straightway you also come to internal page 6.
Yes.
So this is a pleaded case by the management as well as the workman. Now, Miller, come to the page 6. So what is the appreciation of this honorable court? In this regard, the Dasgupta Learned Counsel for the petitioner has vehemently contended that under the provisions of section 10(4) of the Act, the Learned Tribunal was competent to decide the question referred as well as the ancillary question arising therefrom. The Dasgupta has placed before the court that the pre-conciliation communication addressed by the workman raising a demand for absorption as well as the written statement filed by both sides before the Learned Tribunal to show that the dispute between the parties was one relating to the entitlement of the workmen for absorption in Group D post, and the said dispute would not have been understood to be confined to such entitlement arising in the year 1991-92. The Dasgupta has also referred an unreported decision. That is the same decision of the same judge. I have brought this decision, but as this decision is quoted here, so I will not.
It is quoted.
This is quoted that paragraph 14. The Dasgupta has also referred an unreported decision of this court, of the court rendered on such and such date of 25 in WPC number such and such, and contended that the Learned Tribunal had failed to exercise its jurisdiction under section 10 of the Act by refusing to go to the question for entitlement and the workmen for absorption in terms of the policy decision of dated 35/2000. Similarly, reliance has also been placed by the unreported judgment of the apex court. That is such a, well, this is not unreported now, subsequently it has been reported. That is 2008-12 SCC page 275. Yesterday I told them about the page number 2, sir.
This 18 to judgment, 18 to 2009 judgment.
16/5/2008.
Yes,
That-
16.5. ONGC judgment.
Oh, yes,
What is the citation?
that citation is probably 2008 12 SCC page 275. That judgment was relied upon by this court, and that apart from this judgment has also relied upon DCM's case. So I will not refer this judgment.
Okay.
Yesterday, I could not see the volume number. Page number was
You said 275, yes.
275 is clear. Well, volume I was forgotten. Controverting the argument, the advanced Dasgupta Learned Counsel for the petitioner Sri J. Singh, Learned Senior Counsel, appearing for the respondent railway, has contended that the jurisdiction exercised by the, let us go slowly, Lord. Jurisdiction exercised by the industrial adjudicated under section 10 of the Act is referred jurisdiction, and such jurisdiction must necessarily be exercised within the four corners of the terms of the reference. That was their argument, Lord. Made under section 10 of the Act. In the present case, the question referred to the learned industrial tribunal relates to the entitlement of the workmen for absorption in the year 1991-92. The workman concerned in the written statement filed had categorically admitted, this is very much important, admitted that in the year 1991-92, they were not entitled to be considered for absorption in view of their seniority. The Singh learned counsel for the respondents therefore has asked that in view of the question referred and the stand taken by the workmen, the written statement filed in the learned tribunal would not have enlarged the scope of the inquiry. That is their contention, Lord. Scope of the inquiry proceeding to examine the entitlement of the petitioner with reference to the dates or period of time which did not find mention in the reference order. In the reference order, specifically says 91-92, but I acquired my right in the year 2000. So the question of considering that aspect cannot be considered by the tribunal. That was the contention. Therefore, according to Singh, learned counsel for the respondent, there is no infirmity in the award passed by the learned industrial tribunal, and the writ petition is consequently devoid of merit. Here, the learned judge has discussed the rival submission advanced on behalf of the
Paragraph 12.
Paragraph 12 has some bearing that. The rival submission advanced on behalf of the parties have been duly considered. The records exhibited in course of the proceeding before the learned tribunal have been read and considered by the court. In this regard, specific note of the documents exhibited on behalf of the workmen and marked as Exhibit 10-11 will require to be noticed by the court. They went to that extent by the court. By the aforesaid communication, which are of year 2001, the workmen individually and the union representing them had raised the demand for their absorption in grade D post. Such demand was without reference to any specific year or period of time at which the workmen considered themselves to be entitled for consideration for the absorption. The court has also read and considered the written statement. That is very much important. The court, that may kindly be.
Yes.
The court has also read and considered the written statement filed by the both parties before the learned industrial tribunal. A reading of the written statement filed by the parties clearly indicates that the point dispute between the parties was with regard to the entitlement of the workmen for absorption without reference of any particular date or time. There cannot be any manner of doubt about the industrial adjudicator while exercising his jurisdiction in terms of Section 10 of the Act has necessarily adjudicated the question referred to it, and in the normal and ordinary course cannot embark on the scrutiny of question not referred to it. This is the essence of the reference jurisdiction, which the industrial adjudicator exercises under Section 10 of the Act. However, it may so happen that in a given case, the the dispute has been referred. Incidental or ancillary question may be gone into. Such a course of action would also appear to be conformity with the principles for regulation of the industrial dispute as visualized by the provisions of this Act. The broad issue that has conferred to the court in the present case had also arisen proceeding, that is defined another unreported case of the same judgment. Number such and such dispose of such and such. Paragraph 14 of the aforesaid order, which amply sums up the present situation, may be quoted here and there as with advantage. The jurisdiction exercised
You
by.
can skip this, you can come to 13 where ONGC case is referred.
Hmm?
Next page,
Uh,
ONGC paragraph 13, I think that would be.
yes, yes,
relevant.
yes. That's right. So ONGC's case.
Yes, please. read.
That is 2010, 8, 12 SCC page
275.
275.
13 you can read.
No, this is the case, Millard. Now, Millard, another judgment, Millard. This ONGC case has also relied upon the judgment of DCM.
Okay, please.
That is a very first case, Millard. 1967. I can. I will just read one or two paragraphs. Because this ONGC has also relied upon this judgment, Millard. Though it has not been referred here. Now, Millard, paragraph 29. So, about the terms of reference, Millard. Should I read the terms of reference?
Not required. 29. Let us read 29.
Yeah, 29 is the basis, Millard.
Yes.
On behalf of the respondent, Mr. Such and Such put before us 4 propositions, which according to him, the tribunal had to consider before coming to a decision on these 2 issues. They were the fact that there was a recital to a dispute in these issues, the order of reference did not show that the government had come to a decision of the order of reference did not show that the government had come to a decision on this dispute. That is not relevant so far my case is concerned. Second is, the order of reference only limited to the tribunal's jurisdiction in that it was not competent to go beyond the heads of the points of the dispute. There is incidental there to Millard. No, yeah. Not every recital of fact mentioned in the order of the government was irrefutable. And number 4, that is very much important for my case. In order to fix the ambit of the dispute, it was necessary to refer to the pleadings of the parties. No exception can be taken to the first 2 points. The correctness of this third position would depend on the language of the recital. Now, Lord, that was his proposition. Now, the court has accepted this 4th point, Lord. So far, the 4th position is concerned. Mr. Cherry argued that the tribunal had to examine the pleadings of the parties.
Yes.
Pleadings of the parties to see whether there was a strike at all. This is a case of strike and lockout. Whether there was a strike at all. In our opinion, the tribunal must in any event look the pleadings on the parties to find out the exact nature of dispute. Now, this is also a case of strike and as well as the lockout. Because in most cases, that is very much important. The order of reference is so cryptic. That is very so cryptic that it is impossible to call out therefrom the various points about which the parties are at variance, leading to the trial. In this case, the order of reference was based on the report of the conciliation officer and was certainly open to the management to show that the dispute which had been referred was not an industrial dispute at all. So, to attract the jurisdiction of the court, the industrial dispute, under the industrial dispute. But the pressure parties cannot be allowed to go to a stage further and contend that the foundation of the dispute mentioned in the order of reference was non-existent. And that is true, that the dispute was something else. Under section 10(4) Act is not competent the tribunal to dispose. There is, yeah. Now, my lord, another decision, I gave it to you also, no?
Yes.
Here in this decision, my lord, this is also a case arising out of strike as well as lockout. Strike was resorted by the union, and in consequence of that strike, a lockout was resorted by the management. And this lockout was for a long period. The Supreme Court was of the view that lockout was justified and strike is not justified. But Supreme Court came to the conclusion to the effect that yes, lockout, though the lockout was justified, but so much prolonged lockout is not justified. So the responsibility vested was workman as well as the employer. And as a result, 50% wages were given, awarded by the Supreme Court. Now, Lord, straightway, your lordship comes to first paragraph. In this appeal, the special leave arising as such a considering the first whether the dismissal of Robin Bosch, that is not very pertinent so far our case is concerned. Our case is the lockout or strike or lockout as out of the demand for bonus. Particular was justified. And the other, whether the appellant's employees were entitled for any wages for the period between such and such, during which there was a lockout. That was the contributor. Now, your lordship straightway come to page, I have marked some page number, page 3.
Yes.
Whether it is marked, yes.
Yes, yes. Third page.
Third page.
Paragraph?
Paragraph is 8.
Yes.
Start from 8. The terms of reference. I have marked this page number is not there. In my own handwriting, probably it is not marked there.
No, we'll find it out.
Paragraph. Coming to the next to the
yes, that has started. And we are reading which line?
We should also strongly suggest the management and the jointly approach to the labor code, labor directed at once the following issues were following issues. This was the terms of reference.
Yes.
Whether the workmen are justified in stopping overtime as and when they like. Here, what happened, my lord? The workman was not given bonus. At that point of time, the Bonus Act was not in force. So bonus was not a condition of service, but they raised a demand for giving some bonus. And management, there was a dispute with regard to the payment of bonus. And the union resorted strike for 1 day. And then management also resorted to a lockout. The industrial tribunal as well as the Supreme Court was of the view that the strike was not justified. That is the finding. But at that same time, the industrial tribunal, the court was of the view, though strike was not justified, but this prolonged lockout is also not justified. Look, here,
yes.
Here your lordship will find the terms of reference. Here at page 3, I have marked it.
Yes.
Ajay,
Yes.
we should also strongly suggest the management and the union jointly approach the labor director at once with the following issues: whether the workmen are justified in stopping overtime when they like, and number two, bonus. And subsequent to that reference clause, this strike was resorted. Your Lordship will find somewhere. Hmm.
Which part?
First,
This 63, you are relying upon mainly to show that prolonged lockout has been criticized by the apex court. Though lockout as such may be justified, but prolonged lockout is not justified.
and now, my Lord, page 4, my Lord,
Yes.
which I have marked it. Lockout continues till 5/1/1959. There is no such term whether the lockout was justified or not. Lockout continued till 5/1/59, on which the date companies were reopened. The termination of the lockout was brought by a settlement made between parties on such and such. In the settlement, it was agreed that 1% of the sale proceed of the ship repairing section, less sale tax for the whole year, will be paid as bonus to the workmen, irrespective of the profit and the loss of the company. And 15 days wages will be paid to the puja bonus to the workmen every year, irrespective of the profit and loss of the company. It is not necessary to refer the other terms of argument. Now, here your Lordship will find that paragraph 9. It seems to us the attitude of the company was a reasonable one, and that it even proposed to the union and through its workmen that the work should go on. That the dispute should be taken before the conciliation officer for the conciliation. And in the meanwhile, they were prepared to grant some interim relief to the workmen. But instead of accepting this reasonable offer, the union spurned and it contemptuously for coercing the company, encouraged its members to strike on 13/11/1958. It is true that the strike was intended to be a token one, but the object of the strike being circumvent settlement in an amicable manner, even though the company was ready for such settlement, we have no doubt that the strike was unjustified. There was a settlement. Despite this settlement, they have. It is in the light of this finding that the lockout has to be just. In our opinion, while the strike was unjustified, the lockout, when it was ordered to on 13/11/58, was justified. Justified. It seems to us. However, though the lockout was justified and its commencement, its continuance for 53 days was wholly unreasonable. Wholly unreasonable and therefore unjustified. In a case where a strike is unjustified, that is very much important, and that is why this terms of reference is not required. Probably if we go through this judgment, it will be understood.
Yes.
In a case where a strike is unjustified and followed by a lockout, which has, because of its long duration, become unjustified, it would not be a proper course for an industrial tribunal to direct the payment of the whole wages for the period of the lockout. We would like to make it clear that in a case where the strike is unjustified and the lockout is justified, the workman would not be entitled to any wage at all. Unjustified, the workman entitled to anyway. Similarly, where the strike is justified and the lockout is unjustified, the workman would be entitled to the entitled wages for the period of strike and lockout. Where, however, a strike unjustified and followed by a lockout, which becomes unjustified, a case of appointment to blame arises.
Apportionment.
Apportionment of blame arises. In our opinion, in the case before us, the blame for the situation which resulted after the strike and the lockout can be apportioned roughly half and half between the company and the workers. And in circumstances, we therefore direct the workmen to get half of their wages from such and such to such and such. Look, here, of course, there is no such terms whether the strike was justified or unjustified. The court itself has gone to the merit and examined the entire aspect, and court was of the view that there was a settlement, and in despite this settlement, you have resorted to a strike, and management has resorted to a lockout. So this is my submission. Look, just again, I am just traveling your lordship to go page 20 of my writ petition. So
Yes, 20.
that is the corrigendum issue.
Yes.
Now, with regard to the corrigendum, Lord, just a minute, Lord, I would like to, as my friend has pointed out, that a corrigendum where the appropriate government is of the opinion, section 10A,
Yes.
that any industrial dispute exists or appear, it may at any time.
Yes.
It may at any time, not that that corrigendum cannot be issued.
Yes.
It may any time by order in writing. So, and say this corrigendum was issued, whether the workmen are entitled to wait during the period of strike from 27 November 2007 to 29th November 2007, and for the period of lockout from 29th November 2007 to 24th July 2008. So both these issues were referred, strike as well as lockout. The court has to examine this aspect, whether the strike is justified or not, or the lockout is justified or not. It is not that that issue was not referred.
Oh, which provision did you just read
Yeah.
regarding corrigendum?
Just now,
Regarding corrigendum?
corrigendum.
Which provision of law?
Again, oh, provision of law. Section 10(1)
Yes.
of the Industrial Dispute Act,
Yes.
where the appropriate government is of opinion. Existence of the industrial dispute is subject to the subjective opinion of the appropriate government. That an industrial dispute exists or is apprehended. Ma'am, I lost you, but it.
Yes. Yes.
Or is apprehended. It may at any time, by order in writing, refer the dispute to a board, that is not our case, refer a matter to the concern relevant to the dispute to a court of inquiry, that is also not required, refer to a dispute matter concerned with the relevant relates to the labor code, that is 2C. Initially it was referred, but that the union praised that we shall approach to the labor code for detailed terms of paper. And so this was the subsequent.
No, you have said that even to issue a corrigendum, there is a power into the statute. Which is that power? We are not questioning the corrigendum correctness, but where is the power? Is there any power in the provision in the statute?
To issue corrigendum.
Corrigendum.
Yes.
On the, which one?
Section 10(1) itself, at any time. Where the appropriate government is opinion. Appropriate government was of the opinion that an industrial dispute exists. And accordingly, they, in exercise of their power,
This is the first reference. We are asking about concerned about the corrigendum. Is there any
So,
other provision? No.
no, there is no such provision, but it can refer it. Where the appropriate government is opinion
Yes, sir.
that any industrial dispute exists or is obtained, it may at any time by order in writing. So, Lord, this was made subsequently. On receipt of the notice, just paragraph 2. On receipt of the notice, both the parties appeared before this court. The union, namely Assam Carbon Workers Employees Union, submitted a petition before this court
Yes,
that they will approach to the appropriate government for modification of the issue.
Yes.
Accordingly, this could allow time to bring modification of the issue.
Yeah, we have read that.
So this is my case before you. No worries.
We'll conclude the hearing. We'll pass on to the third. The A.K. Dasgupta, Learned Senior Counsel, assisted by M.S.B. Das for the petitioner. Also heard Sri P.K. Tiwari, Learned Senior Counsel, assisted by Sri K. Kolita for the respondent management. The LCR which has been requisitioned has been perused. Full stop, para. Judgment is, hearing is concluded, judgment is reserved.
Fine.
Just only one thing, am I required to give the date of the registration of a new trade union? The second trade union? Because in the write-up, there was a mistake, that's why.
Doesn't matter.
Very well.
It is affiliated to INTAC, we have made the note.
Very
It
well,
is a
very well.
registered union, it is affiliated
registered
to an INTAC, ITN.
Yes. All that is yes. But it was much before the lockout. The exhibit was there. In the write-up, I made a mistake.
The mistake is the date in the date.
Yes,
You
but the
can correct
language
it,
which was
You
mentioned.
can correct it.
Well, I-
Pleading, written,
you registered date with the form.
লিখা তাতে আছে।
For the period, that is wrong.
Some date has been wrongly.
21/6,
You
2004.
make the correction here.
The factual part, there is a mistake in the factual part.
Make this. Yes.
65.
Who's for the other side?
Mr. KP Pathak, Ken Gustami, I know. I charged them, my lord.
How much?
65. What is this matter?
No, my lord, this is too much of content, my lord. My lord, against the interim order. Annexure 2, my lord, at page 6. They violated this order in spite of the
65.
my lord. Page relevant is at page 9. Passed in WPC number 5728 of 2021.
Now, where is Mr. Pathak or Mr. P.L. Goswami or Gogoi? Have you seen the last order?
My lord, that was wrongly submitted, my lord. The state has not filed any writ appeal. my lord. Yeah, it is the private respondent who filed the writ appeal. This is the order, my lord. And my lord, the status quo order was passed.
Okay.
It was the private respondent. The state has not filed any appeal against the final disposal of the both the writ petition.
Okay. But where is the, where are they? Where is the order here?
Here, my lord, first order is at page 6. Starts from page 6 at page 9. In the interim, the last paragraph, the respondent in the forest department shall not proceed further with the tender process in terms of long E auction notice under NIT so and so. My lord, thereafter on kindly come to the next annexure 3 at page 10. This is the work order by violating the interim order passed by your lordship. Against this order also, the writ petitioner filed another writ application 1609 of 2022 at page 13, my lord. This order was passed and relevant order was passed in page 19, my lord.
Where is the division bench order?
Yes, my lord.
Do you have a copy?
My lord. Okay.
This is by the party to the list. Yes, what? Mr. Gogoi?
And the person has filed wakalatnama. And we'll on the last occasion, we reference the court, the order was is assailed in division bench. It's still awaited, madam.
That is by the parties to the list.
My lord.
Nothing to do with the contempt, observation on contempt.
Madam.
So we need your response.
We'll file our response accordingly.
When did you receive notice? Have you filed your response?
No, my lord, we are on the impression that it was the notice is dated 5/1/24. It's not exactly clear, my lord, when it was.
Okay. You will file your reply?
We'll file my reply.
How much time? 2 weeks?
2 weeks.
Let him file the response.
My lord.
Okay. Oh. Heard. 3 G. Bush already standing counsel. Guwahati High Court. Full stop. Also heard. 3 D. Gogoi Learned Counsel appearing for the respondent. Full stop. The order sheet reflects that when the matter was taken up on the last occasion, that is 21/1/2024, it was submitted by Sri Gogoi that the order dated 21/12/2023 of this court was the subject matter of challenge and there is an order of stay. Full stop. Three, Bushra, the learned counsel, standing counsel, has however placed on record, placed before this court, copy of the order dated 21/12/2023, passed in WA 468 of 2023. Full stop. The said writ appeal has been referred by the private respondent in the writ petition and was on the list between the private respondent and the writ petitioner. Full stop. The writ appeal has nothing to do with the observation made by this court and the directions made in paragraph 37 of the judgment requiring registration of the suo motu contempt proceedings. Full stop. The submissions made by Sri Gogoi on the last occasion does not appear to be a correct submission. Full stop. Be that as it may, and in the interest of justice, Sri Gogoi learned counsel is granted 3 weeks' time to file reply to the notice received by the respondent in this proceeding. Full stop. List on on 1st of April.
Can it be on 3rd of April, man?
Then we'll have it earlier.
Man,
29th is a holiday. Okay, 2nd of April?
man, let's take it.
2nd April.
Obliged.
18.
With your lordship, on last occasion also, before this report. Order date 29/7/2022. In fact, we have filed an affidavit, but we could not trace out the petitioner after approval of the honorable court registry, we have filed that. I think the may dismiss this matter.
None appears for the petitioner on call, whereas MSMD Bora Learned Standing Counsel Transport Department is present, who submits that affidavit in opposition have been filed by the respondent numbers
4, madam.
3 and 4 on 5/11/2019 and 27/6/2022. Full stop. Para. The petitioner had remained absent even on the last 2 occasions, namely 8/6/2022 and 29/7/2022. Full stop. It appears that the petitioner has lost interest, is not interested to pursue this case. Full stop. Accordingly, the writ petition is dismissed as not pressed.
I'm deeply obliged, madam.
Due to want of prosecution.
Deeply obliged, madam.
Not pressed, due to want of prosecution.
This may become effective
Infructuous.
Lord,
Other side's presence is necessary. What is the matter about?
Lordship, market
For?
for the ancillary funds that
No, tenure.
tenure is Lordship, 2019 to 2020, Lord.
1 year.
Lord.
Anyone from Mr. Ichari Chaudhary, Senior Counsel Chamber? Okay, we'll have it on Monday. We'll close
Lord,
this. Okay.
Lord.
None appears for the petitioner on call. Full stop. On the other hand, Ms. J. Bora.
Paper.
Ms. J. Bora, learned counsel appearing for the Panchayat and Rural Development Department submits that there is no live cause of action to be adjudicated as the settlement in question was for 1 year, which was over in the year 2020. Full stop para. Be that as it may, and in the interest of justice, let another opportunity be granted to the petitioner. Full stop. Accordingly, the matter is adjourned and is directed to be listed again on 11. 11th, just remind us, we'll close this.
Public.
Item 21.
There was an order passed by the court, last occasion record to be produced. Because we said that 70%, ultimately these are, if it is verified, that we have done the end of the matter. If we have not done the civil court, man.
Yes.
Lordship, regarding this, any instruction, if any, can be only be given by Counsel P. Gogoi, who is on legs, Lordship. Can be taken after some time, if possible.
Is it okay for some time? 3:15 sometime?
Where the records are there,
Lord,
315,
yes,
that's right. I think records, I think it's not there, I think.
Mr. Bhuya, your sometime cannot exceed 4:15.
I understand, Lord.
315.
I understand.
And you're asking Mr. Senior Das to be here.
Yes, Lord.
It will be very, it might be very expensive for you.
Yeah. Actually,
After a while, Mr. Das.
After.
Let's see. AFDC, yes, Mr. Sharma, what is this?
I think all matter may be coming.
Settlement period.
I think it is, party is not interested, Lord. Some development has occurred, maybe not. It's all matter.
We need to have the presence of non-appear for the petitioner on call, whereas Sri P. Sharma, done standing counsel, AFDC, is present, full stop. Sri Sharma further submits that due to efflux of time, there may not be any live cause of action to be adjudicated, full stop para. Be that as it may, and in the interest of justice, matter is adjourned to give a further chance to the petitioner, full stop. List on 11. Monday we'll close this.
Item 26.
26 also, my lord. The infructuous matter, the tenure of settlement is bygone.
What was the tenure?
My lord, it's from 5 years.
Expired when?
It expires, my lord. Way back it, my lord. 2019.
2019?
It has expired.
It cannot be.
My lord, there were some issues, but it has
They
expired.
they approached this court in 21. There has to be some other issues.
The issue there was raised when inadvertently, my lord, they had entered into, normally, my lord is aware.
Okay, we'll do one thing. None appears for the petitioner on call. Whereas Sri D. Gogoi, learned standing counsel Forest Department is present, who submits that there may not be any live cause of action. Full stop para. Further chance Monday, 11.
All right,
We'll have it on Monday.
my lord,
If there is no representation, we'll close it.
my lord. Okay.
Item 28.
Technical matter has already been discussed. Therefore, let me give me some time to place the judge.
Doesn't matter. Do you have got the number?
Asan is that? Yes, thank you.
Sri BP Bora, learned counsel for the, no, heard Sri BP Bora, learned counsel for the petitioner. Also heard MS L Sharma, S Sharma. For who's one? Huh? BCCI. What are you doing here? Where is the match being played today? Is there a match today? You don't know. Who is playing presently? Who is playing against India?
English.
Don't know. What does BCCI stands for? Cricket, not something else.
Now, Lordship, at para 15, we were given to go to the civil court and the limitation of the time consumed in here in this court was excluded. That is the only relief. But this is the judgment.
The present application was filed for a direction for release of an amount of rupees 2,85, 42, 481, along with interest for works done by the petitioner for the respondent board. Full stop para. Sri Bora. Paragraph?
Paragraph 35. 34 and
Sri Bora, the learned counsel for the petitioner, has, however, fairly submitted that a similar issue which had arisen, which was before this court in WPC 5220 of 2021 has been decided wide judgment dated 15/2/2024, whereby a writ petition of the present nature has been held to be not maintainable. Full stop. Sri Bora has, however, submitted that while dismissing the aforesaid writ petition, this court had made certain observations regarding the liberty of the party to approach the appropriate civil court. Full stop para. After hearing the parties and on perusal of the order dated 15/2/2024, passed in WPC 5220 of 2021, record of parties name. The present writ petition is also dismissed. Full stop. The petitioner is, however, at liberty to approach the appropriate civil court for redressal of its grievance. if so advised.
And the limitation part also there, but an observation at where for that's the time consumed in here.
The issue of limitation if arises in case the issue of limitation arises, comma, the petitioner would be at liberty to take recourse to section 14 of the Limitation Act.
This has become contractual.
And Dekaraja,
Yes, Lordship, and
MSN Dekaraja, heard MSN Dekaraja, learned counsel for the petitioner. Also heard B. Sharma, learned counsel representing the railways. Full stop. The challenge was with regard to a communication dated 7/2/2022 issued by the railways by forfeiting the EMD, security deposit and PG means
Performance then.
and performance guarantee, and further placing the petitioner in a holiday list. Full stop. The learned counsel, however, submits that due to efflux of time, comma, the cause of action is no longer surviving. Full stop. Sri Sharma endorses, learned counsel for the railway endorses the said submission. Full stop. Para. The writ petition is accordingly dismissed as infructuous. Item 31 to 36.
Wait, Vijay. These are what?
No, in this matter, my lord, it's a Tina is appearing, my lord. Can be taken up in the next.
What are these matters, Mr. Sharma?
These are matters, 6 matters are there. Out of these 3 matters have to be taken separately. Issue is ultimately regarding non-payment of handling commission for distribution of food grain by the GPSs, the Gaon Panchayat level Vaishnav meetings. Now, these 3 matters, item number 31, 32, and 35, they are covered by a previous judgment of the Honorable Court, wherein there has been an admission to our entitlement by none other than the AG himself. He has appeared, and in the similar matter, regarding the same amount pertaining to some other district, there is an admission that this has been paid. Yes. And accordingly, in those districts, payments has been made.
We can dispose of those matters, those three
Those 3 matters can be done. And the other 3 matters also relating to handling commission, but under a different scheme, and it will be a press matter. But then in principle, it's the same thing.
Okay. We'll try to.
But then segregating them, I think it will be better.
No, we'll try to. We'll pass an order in presence of Mr. Nath. Okay. You have a copy of the earlier order?
Yes, I have annexed it in the judgment itself.
Okay, okay. In the petition itself.
In the petition itself, I have annexed.
Okay.
These 3 matters will also like to take it up.
Mr. Nath's presence is necessary. He said.
I leave it here.
Monday?
Monday.
Heard Sri A. Sharma, learned counsel for the petitioners.
11.
Full stop. Sri M. Chetia, however, M. Chetia, London State Council, however, submits that the state would be represented by Sri D. Nath, the learned senior government advocate, who has some personal difficulties today. Full stop para. List for consideration on 11.
Oblige, Your Honor.
Submit if you order. Yes.
This is my lord, a non-payment of contractual bill. Since my friend,
Yes, petitioner.
he will not come.
Why?
They have got the money, so. My lord, it's an order communication of 5/8/22. This is in, my lord, for this RTGS, we have already,
None appears for the petitioner on call. Para. However, Sri Ardhar, the learned standing council, PWD, has submitted that the amount in question has been paid to the petitioner after deduction of the statutory dues. Full stop. In this regard, he has placed on record copy of the order dated 5/8/2022. Full stop para. Para, he accordingly submits that there remains nothing to be further adjudicated. Full stop para. Be that as it may, and in the interest of justice, matter is, and let another opportunity be granted to the petitioner. Full stop. Accordingly, leaves this case on 11/3. Para. In case of further non-representation, consequential orders will be passed. We have, Mr. Dhar, we have retained this
fine.
item.
Let this matter be fixed after 2 weeks. We need time for reconstruction of the file.
You had made a mention in the morning. This matter you had mentioned.
No.
Okay, otherwise also notice was issued. You file your instructions, file your affidavit.
Where?
Lodha, L Lodha,
Hello.
A Lodha, MS A Lodha, Learned Council. Appearing on instruction of Sri R.M. Das, Learned Standing Council, Water Research Department. Prays for and is granted 3 weeks time to obtain instructions, class file affidavit in opposition. Okay.
Lordship, item number 41 is.
But these are all matters. These are 22 matters. Get it checked. 41. 41, who's there? B.
Your
Sinha,
lordship fixed it, but after
3 weeks. 41, similar.
Yeah.
41, sir. Notice vision approved. Yes.
Oblige, your lord.
My lord, in this case, I was supposed to file the affidavit today. Everything is ready. I have the copy to my learned friend also, but the secretary's wife is suddenly hospitalized. It could not come. I'll file it in the next week, Lord.
My lord, yes, I don't have any problem, my lord. But only thing, my lord, lordship can take up this matter next week. Why I'm submitting, the issue is very simple. One reference was made on the issue of whether the suspension is justified or not. Now, while answering the reference, Labour Court has gone into the merit of the allegation and held that since these allegations were not established, so suspension is not. So that, in my respectful submission, first of all, the Labour Court cannot enlarge the scope of reference, and then the issue of allegation can be looked into only when a decision on imposing penalty is under challenge or before the Labour Court. So, my lord,
sometime next week, or if your lordship takes up it on 12th, so records are here.
So Mr. Holloway, suspension is in contemplation.
My lord, that,
Uh,
only thing
And
that,
it
lord,
is, if in the contemplated DP, the allegations are not able to be proved, then the question of either continuing the suspension or otherwise may not even come. And any observation made by a court of law on the allegation, merits of the allegation, would definitely have a bearing on the.
lord, is that reason for suspension what was shown in the suspension order as well as in the pleadings
See,
report, and labor
see,
court, everything.
there is no requirement to express any reason, but
Yes.
expressing a reason will not make a suspension order bad in law. In fact, there are authorities who say shows that some reasons may be assigned. What is the indication? That only on contemplation, or what is the contemplation? But that itself, going to the behind the suspension order, the justification of the reasons, I don't think that is
No.
the ambit of adjudication.
No, we are also on that point, lord, that whether the reason for suspension shown by the management, whether
It
that
is up to the management. Suspension has otherwise been set aside. You are reinstated. He is not even praying for.
suspension is set aside and we
He's
are
not-
directly
Yes, suspension has been set aside, and now the reason for setting aside the suspension is that the management.
Will interfere with the reasons, but will not set aside the interference of suspension order. Let it be there.
Because, my lord, because of the finding recorded by the labor court that the allegation could not be established, we are not even in a position to decide on the inquiry report. Now,
It-
that decision has been taken.
That is what we have indicated. We may not interfere with the decision of the labor court so far as setting aside the suspension order per se is concerned, but we will say something on the reasons
So
aside.
that,
So,
We'll have it on Tuesday next.
Tuesday, 12, I have some problem. After 12,
Your affidavit may not be necessary yet.
yes, records are here.
if on 14, 12, I have some
14th,
person.
okay.
Okay.
Heard Sri S. Chakraborty, learned counsel for the petitioner. Also heard Sri K.M. Haloi, learned counsel for the respondent number 2, who submits that the affidavit in opposition is ready and will be filed shortly. Full stop.
I have
Para.
found a copy.
Shortly, and in fact, copy of the same has already been served upon Sri Chakraborty. Full stop. Para. In the interest of justice, list this case for consideration on 14th of March. Affidavit in opposition, if filed in the meantime, may be tagged with the records.
But
67, submit.
Yes.
Wait.
What is this? Yes.
May please, Lordship. Lordship, the respondent number 6, that is the Sirajul Haq. He is a purchase license holder of a fair price shop. And
Mr. Hawk's client. Who? Mr. Hawk's client.
Lord.
Okay. Then
And Lordship, the locality, the people of that locality find the consumer, that is the consumer, find many irregularities of his practice. Lordship, an inquiry was, and people and the consumer complain against the respondent number 6.
oh, yes.
Lordship, after finding, Lordship, an inquiry was conducted. Sirajul Islam against the Sirajul Islam and his shop by the area inspector,
Yes.
and the finding of that report is on page number 15 of 15, Lordship.
One
Annexed
five.
3.
1-5.
Yes, Lordship.
Yes. Yes, what happened?
And in that is Lordship, in page number 18. Assistant Commissioner Lordship cancel the license of the respondent number 6.
Page number
Page number 18.
18.
18, that is conclusion. Here is written, Lordship, in
Okay.
written that that Sirajul Islam has violated as many as 8 clauses of Assam Public Distribution of Articles Order 1982.
Yeah.
Following Lordship, that is following his
This is what? Enquiry report.
yes, Lordship.
Enquiry report is against the petitioner. It is against,
Respondent number
against the respondent 6.
Respondent number 6.
Thereafter what happened?
Lordship,
Thereafter
He-
what happened?
thereafter, Lordship, his license was cancelled.
When?
In view of the above finding, I would like to humbly submit that inquiry report for your kind will not touch.
Where is the cancellation?
Suspended.
Where is
But
suspended?
it is 20.
22, Lordship.
22.
Yes, Lord. Additional Deputy Commissioner.
Yes, suspended.
Yes, Lordship. In second, para in view of above, I see Dipankar Das ACS, Additional Deputy Commissioner Naga, Princess Kaliapur Subdivision, do
Yes.
hereby suspend the license bearing number so and so in exercise of power conferred under. It is
Yes.
in
Yes, then?
thereafter, Lordship, his suspension order was the respondent number 6 appeal before the Commissioner, Central Assam Division,
Okay, appeal filed.
and his cancellation suspension order was set aside, Lordship.
Yes. Which page?
32, in page number 32, Lordship.
32. Yes. Yes. What happened?
Lordship, the order
That set aside. Okay.
set aside, or that the order may be set aside, Lordship.
Yes. Appeal allowed.
Yes,
Appeal was allowed.
Yes,
There,
appeal was-
yes, now,
now, Lordship, he is still running his top, Lordship.
who are you?
I am also, Lordship, consumer.
You are one of the complainant.
Yes, Lordship, also complain.
Where is your complaint?
Lordship, in page number 11, annexure 1, Lordship. There
Yes.
are other complaint, Lordship, in page number 13 to 14. That is that is annexure 2, 1 and 2.
What is your name?
Zakaria Hafsa.
This is by you. Page number 11 is you.
Yes, Lordship.
You are the district president of a political organization.
Yes. No, Lordship.
Huh?
District President, BJP, Koliabor District Minority.
You are a consumer or you are a political party?
No, Lordship.
You are very proudly using your letterhead with a seal of your party.
No, Lordship. There is another complaint filed by the consumer.
So where
That
are
is
they?
in page number 13, Lordship.
Where are they?
Page number 13, Lordship.
Where are those persons before us? Where is Parvina Sultana, Ayesha Khatun,
Ayesha
Afia
Khatun,
Begum
Afia Begum.
before us?
They may be called, Lordship.
Hmm?
They may be called, Lordship.
By whom? Who will call them?
Lordship, the court or
Court doesn't have any other business. Call persons who are not interested to come to the court, not connected with the lease. What is your right? Yes, Mr. Hawk.
Lordship, Lordship, first of all, he is neither a consumer nor the resident of that area. So as to show his power, he filed a complaint at the.
He is not a consumer.
Not a consumer, not the resident of that area. I have filed opinion opposition, especially I have mentioned, they have not. Lordship, in my opinion opposition, page 36, the deponent further backstates that the petitioner is neither the resident of the
Page?
locality. Lordship,
Page?
page 36 of that opinion of first paragraph.
Yes.
The deponent further backstates that the petitioner is neither the resident nor of the locality nor the consumer of that under the fair price of the deponent. The petitioner is the president of the Koliabor district minority morta and he is the president resident of Rupohiat constituency. The petitioner filed a complaint against the deponent with ulterior motives as to harassment. So he has no any understanding to file a complaint, and he is no way affected. And the order passed by the landed commissioner rightly passed the order, and there is no any permit. After hearing both the parties, the order of suspension was
Lordship, the inquiry report clearly shows that the respondent number 6 violated the terms and conditions, Lordship. And also mentioned many complaint was against that against the respondent number 6.
Doesn't seem to be a bona fide exercise. What is your name, counsel? What is your name?
A. Muhammad.
M. Ahmed.
A. Muhammad.
A. Muhammad.
Yes, Lord.
Doesn't seem to be a bona fide exercise. Mister,
Inquiry was done on the basis of the complaint. But it also stated that the inquiry was done on the basis of the complaint and some statement of the consumer was yes, so that. Therefore, my lord, there is no other material that defined.
see, if you even read the report of the inquiry officer at page 15, the background, the first and foremost, the objective of consideration or having the inquiry done is the petition by the present writ petitioner. It also takes into account another complaint petition by 60 number of consumers. Okay. Now inquiry was done, something was found against him on recommendation was taken into consideration and his license was suspended. He has the power to file an appeal. Appellate authority has interfered. His license has been restored. Now the complainants, the consumers are not before this court. And Mr. Hawk's contention is that the present petitioner is neither a consumer nor even a resident of that area. Under those facts and circumstances, at
Yes,
the
no,
instance of somebody, can it be challenged? If there are genuine complaints, lodge the complaints, get it done. What has happened to the proceeding otherwise? Did you initiate a proceeding against Mr. Hawk?
Lordship, so was notice was.
When he filed the matter, so was notice was within matter.
Thereafter?
Thereafter, my lord, it was not a suspension order, it was before matter. I didn't know material.
So in one of the cases, we have held that unlike a disciplinary proceeding, under the orders of 1982, suspension itself can be treated to be a punishment, and it is not necessary to be followed by a proceeding, because two parts are there, 1 and 2. 1 only talks about suspension, ends there, and 2 is a separate part.
My lord, against the suspension also he can file an appeal. My lord. Since he has filed an appeal, my lord, in that appeal, the suspension order was said, my lord.
No, that is what we are trying to say. A suspension order need not necessarily be followed by
Yes.
a proceeding, unlike a disciplinary proceeding or any other thing. Heard Sri A. Muhammad, learned counsel for the petitioner. Also heard Sri M. Chettiar, learned state counsel, whereas Sri N. Hawk has appeared for the respondent number 6, who has also filed an affidavit in opposition on 27/2023. Full stop. Para. Have your seat, please. The subject matter of challenge in this writ petition is an order dated 14/10, no, not 14/10, 24/2017, passed by the Commissioner, Central Assam Division, Nagaon, whereby the appeal preferred by the respondent number 6 in respect of suspension of his fair price shop license has been allowed. Full stop. Para. As per the projected case of the petitioner, the respondent number 6 is a fair price shop owner against whom the petitioner and some other consumers had lodged complaints. Full stop. Based on the said complaints, inquiry was conducted by the area inspector, who had recommended, who had arrived at a finding of violation of the contravention of the order of 1982. Full stop. Based on the said findings of the inquiry report, an order was passed on 12/9/2016, by which the license of the respondent number 6 was suspended. Full stop. Against the aforesaid order of suspension of license of the respondent number 6, he had preferred an appeal on 14/10/2016. Full stop. The appellate authority, namely the commissioner, comma, Central Assam Division, comma, Nagaon, after consideration of the appeal, had passed an order dated 24/2017, allowing the appeal, and accordingly, the license of the respondent number 6 was restored. Full stop. Para. Sri Muhammad, the learned counsel for the petitioner, has submitted that the inquiry report, having found that the respondent number 6 was indulging in malpractice in running the fair price shop, comma, the appeal should not have been allowed, and therefore the instant challenge has been made. Para. Sri M. Chetia, Learned State Council, however, submits that the order of 1982, O2 capital lever, itself provides for preferring an appeal, and the appellate authority, by exercise of powers and on perusal of the facts and circumstances, has passed the order dated 24/2017, which does not appear to be suffering from any legal infirmity. Full stop. Para. Sri Hawk, the learned counsel for the respondent number 6, has, while endorsing the submission of the learned state council, has raised a serious question on the bona fide of the present petitioner in filing the present writ petition. Full stop. He submits, and by referring to the affidavit in opposition, comma, more particularly the averments made in paragraph 4 thereof, comma, he submits that the petitioner is neither a commissioner, neither a consumer, nor a resident of the area in question, and therefore does not have any locus to maintain the present challenge. Full stop. He submits that the petitioner is a political person, and only for political reasons, comma, the complaint was filed by him, which triggered into the enquiry, followed by the suspension order, which was ultimately interfered with by the appellate authority. Full stop. Para. The rival submissions have been duly considered. Full stop. The petitioner has annexed the complaint lodged by him against the respondent number 6 Full stop. A perusal of the complaint would show that the petitioner is the district president, was the district president at that point of time of a political party. And the complaint itself was made in the official pen, in his official pen. Full stop. Do another complaint by containing 3 more names have been annexed, comma, those persons are not before this court challenging the appellate order dated 24/2017. Full stop. This court has also noticed that the categorical submission made by the respondent number 6 in the affidavit in opposition dated 27/2023 that the petitioner is not a consumer and not even a resident of the area in question have not been denied or refuted by the petitioner by filing any rejoinder affidavit. Full stop. Para. The order dated 24/2017 would reveal that the appellate authority had taken note of the appeal and also the orders of this court passed in earlier round of litigation. Full stop. The appellate authority had also come to a finding that there was nothing on record to demonstrate that the appellant within bracket present respondent number 6 had violated the terms and conditions of the license or the Assam Public Distribution Order. Full stop. The appeal being provided under the orders of 1982 and powers exercised therein by the appellate authority can be interfered with only when a case is made out that there was no consideration of the relevant factors which does not appear from the order dated 24/2017. Para. This court is also of a considered view that there is no bona fide on the part of the petitioner to institute the present challenge. Full stop. The petitioner, who appears to be a political person, is not even a consumer or a resident of the area in question. Full stop. The consumers, though another complaint of certain persons said to be consumers have been annexed to the writ petition, comma, those persons are not the petitioners in the instant case. Full stop. Para. A writ court being a court of equity, comma, the bona fide and the bona fide of a person is of paramount importance, wherein there is a requirement, basic requirement to approach this court with clean hands, which does not appear to be so in the instant case. Para. Accordingly, comma, the writ petition is dismissed. Full stop. Further, considering the background which has been discussed above, this court imposes a cost of ₹25,000 upon the petitioner. Full stop. The cost has to be paid in the name of the Guwahati High Court lawyers. No. Not value, welfare fund.
But
Yes.
may I pray that this matter come after 1 week?
Why 1 week? We'll have it on Monday.
Okay.
Monday. Okay. No. Those three, Didas, Learned Senior Council is present, comma. Accommodation has been sought for on behalf of Sri Dinath. B. Gogoi. Learned Standing Council, Public Works Department. Full stop. In the interest of justice, list this case on Monday?
Monday.
On 11/3. On which date? Sri Gogoi, the Learned Standing Council, may appear with the relevant instructions.
What a black. Wait, in this case, Lordship, the petitioner has made payment of substantial amount of the used Lordship. So few amount left, and his the petitioner informed me that within a month or two, the amount will be paid. So,
Want to
Lordship,
withdraw
matter-
that? You want to withdraw this?
not now, Lordship, matter may be taken after
No,
4 weeks.
17 matter. How
Yes,
much how much amount has been paid?
Amount was 39 lakh and
How
something.
much has been paid?
Till now 16 lakhs has been paid, but he shall pay the remaining within 6 months, probably.
Who will pay?
The petitioner.
Oh, you are supposed to pay.
No.
No, they
I'm the petitioner. We have to.
You have to pay.
Yes, sir.
Pay to whom?
Pay to
PF
the PF commissioner.
Provident fund dues,
Provident
my
fund.
lord.
Oh, you have not paid.
It was actually, I
Originally-
paid the principal amount, but the default amount accrued up to 43 lakhs.
Yeah,
and
for the
that-
PF.
Yes, man.
What do you say?
My lord, I have to obtain instruction.
We thought that you have to pay him. He has got a substantial amount. Oh, then, of course, we have to adjudicate the matter.
Yes,
What
sir.
is your challenge?
Lordship, in this case, I challenge two letters. Lordship, may kindly see page number 61.
But you say that in the meantime, you have started paying and you have paid substantial amount.
Yes, Lord.
Let him have the instructions then.
Yes,
Item number
68.
Sri R. Sharma, Learned Counsel for the petitioner submits that during the pendency of this writ petition, comma, the petitioner has cleared a substantial portion of the PF dues. And he accordingly prays for some more time so that the up-to-date instructions can be obtained by him. Full stop. Para. Sri Chakraborty, Learned
225 meters. That's one.
Standing Counsel, PF Commissioner is present. Full stop. Para. In the interest of justice, 17 matter.
Yes, sir.
Will fix it list on on 5th of March, 5th of April.
Deep here.
69.
Wait, Mr. Lord. This is a small issue regarding.
It is on the last page, and I.
No, doesn't matter. We asked your name to be
My lord,
reflected, yes.
It's the first time it's come on a 2 weeks time. I'll file my affidavit as well.
Affidavit
It
not
may be
filed.
Not record, in fact.
You get
It
the
is required,
instruction.
my lord. It is.
Why you get the
They have
records?
challenged the order of the EI court, my lord. And they have come with a way of to the question of mental ability in our affidavit.
Maintenably issue, why should you need an
Madam.
affidavit? It's a law point. Which one? 85 or what was 75 or 85?
No, 75 was regarding to the dispute, and they have approached this court by an order of the EI court, not by appeal by 226.
What is the appellate provision? 85?
82, madam.
82.
82. 2 weeks time, I'll file my reply, and any date may be fixed.
These are 18 matters.
My lord, 2 weeks.
Okay. Heard Sri A. Sharma, learned counsel for the petitioner. Full stop. Para. Pursuant to the order passed by this court on the last occasion, that is, i.e. 4/3/2024, 3 M. Smith, understanding the present standing counsel ESI has appeared. Full stop. Para, the learned standing counsel prays for some time to enable him to obtain the instructions / file affidavit in opposition. Full stop. Para. List after 2 weeks.
Interim order may be con.
Para, interim order passed earlier to continue till the next date fixed.
Obliged.
1070.
Please, Lord. Matter pertains to non-payment of bill to the petitioner under direct payment system by the power grid. Lordship. Lordship may kindly peruse the order dated 19/2/2024.
Yes, madam, what do you say?
Lordship, as per the last order, Lordship 23 to 24, we have put the letter to your Lordship. Lordship, by the letter, we have made payment of the rupees 10 lakh on 4/1/2016 itself, Lordship.
This mail has been sent by Mr. Ongsuman Pandey. Is apparently prima facie Lordship incorrect, because this, as per this instruction, this amount, two amount we admit. It is as per we paid. It is first and third. The second amount, as per this, it was paid on 4/1/2016. Whether it is regarding different contract. Now, in the right side, last column, Lordship,
We don't have that letter with us.
it is, it was placed on the last occasion. In the
Lordship, it was placed now.
in the order sheet also it is affected.
He made Lordship, 22nd of February 2006.
No, that order we have.
The
Twen-
letter was also placed in the court.
Give a letter, isn't it? That's not a problem. We can have another copy. That's not an issue. That is an. Okay, today we may not have the time. If he's disputing, why don't you file an affidavit?
Affidavit we have filed, Lordship.
No, regarding this payment.
Regarding this, yes.
If you say that this is a payment towards present claim and he's disputing, he says that it is for another contract.
They have filed affidavit in opposition, so they are also, they did not mention. Now with the.
No, this is a
No, it is earlier. It is even,
Subsequently, we have received, Lordship.
This is a latest development.
no, not listed. It is dated 4/1/2016.
Lordship, payment
They are
was made
claiming,
must be for filing of the writ petition, Lordship.
yes, but our claim is, it was approved by them for 5 lakhs. It is on, it is thereafter Lordship. It is in different, it is
It is not
29/7/2016.
Okay, you file the affidavit.
Lordship,
You put
it
this
was
on
approved
record.
for 5 lakhs, we have paid 10 lakhs. It's important what they have paid.
Different contract.
Heard Sri S.D. Purkasta, learned counsel for the petitioner, para. And a Sam D.B. learned counsel appearing for the Power Grid Corporation of India
Okay.
Limited has limited by referring to the order dated 23/2/2024 of this court has submitted that a communication dated 22/2/2024 was placed on record as per which an amount of rupees 20, an amount of rupees 10,50,880 was already paid to the petitioner. Full stop.
On date when you mentioned, Lordship, 4/1/2016.
It is not here. We do not know. We are putting the order. Order copy will not, it's not recorded. Para. Sri Purkast, the learned counsel for the petitioner, however, submits that this statement does not appear to be a correct statement and in any case is not related to the present claim. Full stop. Para. Let an affidavit be filed by the respondent corporation stating the background of this payment and also by annexing the relevant documents. Full stop. Let such affidavit be filed within a period of 2 weeks from today.
Obliged.
Okay, rest of the matters that we'll give dates. Mr. Goswami, Mr. Rajchandra Goswami, which matters?
7.
We'll have a date. Which was same matter.
We are not adversary to each other, we are friends. 73.
We'll have some date. What is your matter?
As per last order, they have to give the compliance order. Now, I have received one letter. You can clarify, look.
We have complied the order, the speaking order. It's a lot, may close it with a liberty to us that we can typographical error lot in the order. That's how yesterday order was passed.
So Lordship will fix it better next week. They will pass it.
No, Lordship, the order, in other sense, Lordship, the order was.
Have you seen a copy of the order?
Order is, he has assured that everything will be okay.
Everything,
But it is
the order
wrong
was a 2% speaking order. But speaking order was in fact in favor of them, but in parity, it becomes I am, Lordship. It become M. In place of N, it came as the M. It should have been in parity with all of 14 bills. It came I am came, Lord.
Okay, you get the correction done. Okay. Third Sri S.K. Goswami, learned counsel for the petition. Full stop. Para. Sri P. Sharma, learned standing counsel, FDC.
No, contempt. It is contempt.
Oh. Sri P. Sharma, learned counsel appearing for the respondent, however, submits that the order has been complied with and in this regard.
Some typographical error is there.
The communication has also been issued, full stop. However, there appears to be a typographical error for which he seeks some time to obtain the clarification. Full stop. Para. List, in the interest of justice, list on 15th of March. Okay.
I love that.
Next. Any matter where interim orders are
No,
doing today?
73 of Lordship can sit on 12. 12.